Two channels coming together. Oh yeah. True crime team, you better know. After the facts and defense rest, let's go. Bringing justice, doing their best. Woo! Facts are flying, truths unfolding. Criminals shaking, their stories holding. Defense rest, got the legal mind. Together they solve, justice they find. All rise, the truth's in the house. Y'all, bring it up, breaking it down. Hear that call? Facts and defense, a mighty blend. Oh yeah, justice ain't gonna bend. Gavel hits, the facts commence. Defensive moves, we've got the sense. Teamwork strong, no crime secret. Yeah, they're bringing justice. Best believe it. Ooh yeah.
State ready?
State is ready to proceed, Your Honor.
What are you going? All right, let's go ahead and I'm going to have the bailiff go get the jury.
I got one.
Bailiff, go get the jury. That's fine. Just we'll put her a cup of water. We're not going to rise till the bailiff pops his head in. Say this sheet will be a 14 foot, right?
Correct.
Yeah, eight, for the record, 8 and 63 is not. 8's been identified in that area, 63 is not been identified.
Yes, Your Honor. I just have one exhibit to 64.
Just 164, not
164.
All right.
All right.
All right, everyone have a seat. Members of the jury, I reminded you last night and want to emphasize to you today, it's important that you decide the case based solely on the evidence and the law presented here. So you must not learn any additional information about the case from sources outside the courtroom. To ensure fairness to all parties in this trial, I'll now ask each of you whether you have learned about or shared any information about the case outside of this courtroom, even if it was accidental. If you think you might have done so, I'm going to ask you to raise your hand. I'm going to go down to each of the jurors. I'm going to start with 1 through 4, 5 through 8. Once I see a raise of hands, I may break up the jury and bring everybody in individually. Thank you for your adherence to my instructions. So, Juror 1, have you heard anything or seen anything about the case?
No.
Juror 2, have you heard or seen anything about the case?
No.
Juror 3, have you heard or seen anything about the case?
No, sir.
Juror 4, have you heard or seen anything about the case?
No.
Juror 5, have you heard or seen anything about the case?
No.
Juror 6, have you heard or seen anything about the case? Juror 7, have you heard or seen anything about the case?
No.
Juror 8, have you heard or seen anything about the case?
Yes, sir.
Okay, we're going to be in our final day today, so pay close attention and we're going to begin. State, call your first witness for the day.
Yes, Your Honor, the state calls Dr. Uriel Schock. And just putting,
Please, absolutely. More, Doctor.
Please raise your right hand. Do you solemnly swear or affirm that the truth, the whole truth, and nothing but the truth, so help you God?
Doctor, you're gonna step this way. Step around, have a seat right there.
We've got some water and stuff.
Thank you.
Thank you.
you ready, Doctor?
Yeah.
And if you could please speak up and state your name for the record, Doctor, please. State your name.
My name is Vera Volnikh. It's Volnikh.
And how are you employed, ma'am?
I employ as associate medical examiner at the District 10 Medical Examiner Office.
And how long have you been a medical examiner?
20 years.
Could you give the jury a brief idea of your educational background?
I graduated from medical school in Havana, Cuba. I completed my postgraduate training in pathology at the University of Puerto Rico. And after that, I completed my forensic pathology training at the University of South Florida. And after that, I was employed at our current office here in the District 10.
Are you a licensed physician in the state of Florida?
Yes.
For how long?
21, 22 years.
And you said you're a medical examiner. What are your duties as a medical examiner?
The main duty of medical examiner to determine the cause and manner of death, or how is the person died and why is the person died.
Approximately, and are autopsies a regular part of what you do?
We perform about 300 to maybe 350 autopsy per year, every year, depends.
So how
Sometimes
many-
less, sometimes more.
So approximately how many autopsies do you believe you've performed?
In 20 years,
Yes, ma'am.
a lot.
Fair enough, ma'am. I think you've given us idea of the numbers that we're dealing with, unfortunately. In your personal experience as a medical examiner, have you performed any autopsies on infants?
Yes.
Let me ask you this, Doctor, you mentioned some practices. What is forensic pathology?
Again, the main goal of forensic pathologist or medical examiner to determine the cause and manner of death, or how is the person died and why is the person died.
And have you ever testified as an expert before, Doctor?
Yes,
And how many times?
many.
Many times. Have you testified as an expert in your area in Polk County previously?
Polk County, Hardy County, and Highlands County, which is our District 10.
Your Honor, at this time, the state would tender the expert as far as qualifications are concerned.
Defense?
Okay.
All right. Doctor, you are considered an expert in this court files and for the jury. Thank you, Your Honor.
Doctor, I would like to now direct your attention to November 2nd of 2022. On that date, were you asked to perform an autopsy on a baby by the name of Uriel Schock?
Well, I was not asked. Once somebody die in our jurisdiction, we get a call, depending where the body is. Hospital, the scene, we will get the call to our office. Somebody present the case. We determine that the case, medical examiner case. Once we determine it's our case, we will dispatch our transport to the place where the body is located, and we will bring the body to our office. Once the body arrives at our office, whoever on that day on duty will perform the autopsy. So we are obligated to do that.
Pardon my poor choice of words. I guess I should have said, were you obligated to perform the autopsy? So you did perform an autopsy on Uriel Schock?
Yes, it's of course it depends case by case. Sometimes we don't perform autopsy if we have enough information. Let's say somebody been in the hospital, we get review of medical record, medical history, and we may determine the cause of death, including the manner of death. But in the infant or children's, we almost always perform the autopsy to see what happened.
Why is that, doctor?
Well, children cannot talk, infants cannot talk. Sometimes we have to exclude all the possible causes of death, like trauma, intoxication, any diseases that the children may have, which was not diagnosed. So we have to look at that to determine the cause of death.
And in this situation, how do you normally start out conducting that process?
Well, in this particular case, we get the call from the hospital, and they say there was a child that left in the car for several hours. So we say, okay, this looks suspicious, so we will bring the body to our office to examine. Again, we dispatch our transport. The transport will place the body in the body bag as is, seal the body bag, and that bag will be transported to our office. Once the body arrives at our office, we will open the body bag. We will take series of photographs of the body as is in the body bag, with any medical equipment attached or any clothing that on the deceased. After that, we will remove the body out of the body bag. We will remove all the medical devices, clothing. We clean the body, and we'll take another series of photographs of the body, front, back, from all the angles. The reason we do that is to show presence or absence of any injury on the body. That's what we do. And
if I may, doctor, in this instance, since we're talking about the external examination, did you notice any of that, any evidence of any trauma or anything like that?
When we do the photographs, it's kind of part of examination, but we just do for preservation purposes, we do all these photographs. And like we say, then we decided, okay, we're going to do autopsy. Autopsy has two parts. External examination, which include looking at the body, see if there is any injury on the body, visual injury. Sometimes you can have visual injury from externally, but or you have no injury externally, but you may have something internally. So if you find something, we document it. Again, with the photographs and with the description. So once we perform the external examination, we also, before we open the body for internal examination, we also do the x-rays on the body, especially in the children's. We look for any acute or older injury of the bone, of the extremities, or the ribs. So we look if there is any previous injury that have been healed. And we didn't find any on this case, neither we have any external injuries on the baby.
So you did not note any external injuries?
She did not have any external injuries.
And What is the, after you finish the external, you also mentioned before you go internal examination. Is that what you would have done next in this case?
Yes, then once we do the external examination, we proceed with the internal examination. That means we will open the cranial cavity, we look at the brain, we open the chest cavity, we look at the organ, heart and lungs. Then we look at the abdominal cavity, if there is any infection, any trauma, anything that will explain why this child died. And we also collect the body fluid of the body. We take eye fluid, blood, we take urine, stomach content if it's available. And we send that to toxicology labs so we exclude or confirm any substances that may contribute to the death of this child.
And from your internal examination, did Uriel suffer from any infections or substances or anything like that that caused her death?
No, no. Also, like there's some substances can elevate your core body temperature, like amphetamine or cocaine. So we always look for those two, and obviously we didn't find anything. We find no evidence of trauma. We have no evidence of any disease. So there was nothing to explain her death, except that she was in the hot car. And that's...
So, doctor, let me put it this way. You reviewed and you did your examination. Did you come to any conclusions about what the cause of her death was?
Yes.
And what was that?
We say that she died of hyperthermia.
And what is hyperthermia, doctor?
It's elevated body temperature due to either drugs, diseases, or environment that contribute. In this case, that she was in the car, left for a couple of hours. We came to this diagnosis by excluding all the other causes that can be like trauma, infection, intoxication. So we say that she died of hyperthermia.
And hyperthermia, is that something that's instantaneous, doctor?
No, this is not instant death. She will die slowly. If you leave somebody in the car, in the enclosed car, about 10 minutes after, the temperature in the car probably rise about 19 degrees more than outside. So if you have outside 90 degrees, in the car it will be probably 110 degrees. If you leave for 40 minutes, the temperature inside the car rises up like by 40 degrees more. So it's 130 degrees. So now when your body temperature is, you are there, so your body start fighting this heat. So what the body does, the blood vessel dilate. She will try to sweat, because when you sweat, the fluid evaporate and it's cool the body. But if she's long time in the car, then she start, losing that fluid. Her blood pressure going to drop. If your blood pressure drop enough that it's not going to deliver proper oxygen to your brain, you start suffering. With your neurons start dying, so the brain starts swelling. You will become unconscious, not dead yet, but unconscious. You may have seizures. Also, if your brain don't have oxygen, enough oxygen for about 10 minutes, you will die. You become brain dead, and that's irreversible. If she rescued before she's brain dead, she may or may not recover, because not only the brain suffer, the other organs also suffer. You can have liver failure, heart failure, kidney failures because of the heat, and because again there's no enough blood, oxygen going to the organ to sustain the life of those organs. But no, this is not instant death.
So, doctor, based on your professional opinion, would Uriel have died had she not been left in that hot car?
There is no reason why she will die. She was completely normal, well-developed, well-nourished child.
Thank you, doctor. I have no further questions. Oh, I do have one question. I take that back, doctor. I'm approaching you with the pre-marked state's exhibit number 64. Do you recognize that, doctor?
I do.
And is that Uriel Schock who you performed the autopsy on?
Yes, that's we call it just picture, identification picture. So we just take the face for identification purposes.
Your Honor, this time the state would seek to enter into evidence state 60.
Defense?
No objection.
Okay, we need to have it.
And Your Honor, with that, I have no further questions.
Okay. Submitted without objection. All right, defense, any questions? Director Cross?
Yes, Your Honor. Please keep going. Just very briefly. Doctor, you remember Detective Semendel, also known as Detective Fletcher?
No,
You remember speaking with her?
no,
You don't remember telling her that the death of this child was sudden and quickly?
no, I will not say that. This is not sudden death. The sudden death is something that
Ma'am, did you say that? That's my question.
you
To
ask
her?
me if I remember, I do not.
Okay.
And
And did you
it's
say
not
because
instant
of the
death.
contents of
Hang
it?
on a second. We need to ask a question, let her give an answer. and we'll
Did you didn't tell her because you looked at the contents of the stomach and you could tell that the death was quickly?
quickly and instant, it's not the same. The quick mean less than an hour after person eat, and if it has something in the stomach, it will depend on what the child eat. If it is formula, it could be there for 2 hours. If it's breast milk, it can be only 30 minutes, maybe at them you don't have anything in the stomach. Again, it's not instant. It's quick, but not instant.
Say quick, but not instant.
It could be an hour. That's quick too.
Thank you, ma'am.
All right, State.
Yes, Your Honor, briefly. Doctor, I want to just focus on the questions that was just asked to you. You said that based on the stomach contents and how quickly they're gone. Obviously, if you had information about when Uriel last ate, it would be more useful and more useful to your opinion on as far as what quickly is. Is that safe to say?
Well, again, we know that she has something in the stomach. So whatever she eat, which I don't know what time she eat, she still have some food in her stomach, partially digested food. So that means that she don't digest completely. Like I say, if she eat formula, it stay almost for 3 hours. So it's maybe less than 3 hours that she died since she eat last time. Again, I don't know what time she eat, but it's not instant death.
Okay. And so that just so it's clear, when you say quickly, you're not talking 5, 10, 15 minutes.
Again, quickly doesn't mean instant. It's not instant death. She was, alive to produce all that sweat that this child have, because when we receive these kids cases, we have also information from, let's say, EMS, law enforcement. So we read all the report. And we know that the child was, her clothes was completely soaked of sweat. So that means that child was alive for some time to produce that amount of sweat. So again, quickly could be an hour. If the temperature rise very fast, very high, she cannot, even the adult cannot sometimes overcome the hyperthermia. In the children, it's even worse. They get very hot very quickly. So again, they try to sweat, but because they cannot overcome that insult, so they became unconscious first, and then they die after the brain dies.
So is it fair to say that when you use the term quickly,
Leading question, Your Honor.
Overruled.
so when you use the word quickly, it's more of a term of art compared to hours compared to days? Would that be safe to say?
Correct.
All right, no further questions.
Okay. May this witness be excused?
Yes, Your Honor.
Defense, do you agree? All right. Thank you, doctor. Have a nice day. You're free to be in business.
Thank you.
All right, state the next witness.
Your Honor, the statement of the witnesses at this time, I believe all the evidence has been entered. I checked with the clerk. The state will rest.
All right, state rest. Let's take a stretch break, members of the jury.
All rise.
We'll get you back here in a few minutes.
You may be seated.
Everyone have a seat. State's rest. Defense, anything we need to go over?
Yes, Your Honor, Mr. Schultzman, how are you?
Okay, go ahead. Mr. Shaw.
Your Honor, at this time, we make an enforcement motion to dismiss count one. Sorry, ask for a judgment of acquittal on count one.
JOA, okay. State brief argument.
Your Honor, the state has put on a prima facie case. It's given enough to make this an issue for the jury to determine whether or not the acts of Tracey Nix were simple negligence or culpable negligence based upon the surrounding circumstances. Culpable negligence cannot be determined without a jury looking at those circumstances that surrounded the negligence and determining if they're wanton and reckless. And I believe the state has put on enough evidence for the jury to make that decision.
All right, based upon the states presenting a prima facie case, this case goes to the jury. JOA is denied.
Your Honor, for the record, what I'd like to make argument, and I'd also like to present just a copy of the order from the Florida Second Circuit Court. It's not binding, obviously, but it is persuasive.
Is this for count two?
This is for count one,
Okay.
culpable negligence.
All right, go ahead and, all right. Go ahead.
Your Honor, the definition of culpable negligence requires someone consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. The evidence presented yesterday and today by the state in its case does not demonstrate any conscious action by Ms. Nix. In fact, all of the conscious actions taken by Ms. Nix that day were for the benefit of her family. She was doing a favor for her daughter. If you watched her in the video, you saw her put the child in the car seat. What would have been reckless would for her not put the child in the car seat, put her in the backseat of the car and just drove around like that. All of her conscious actions, and you heard from witness testimony from the three friends that she had lunch with, that she was behaving normally, that she was a loving, caring, doting grandmother, that she was happy, that the child was happy. All of that demonstrates that she was acting in an appropriate manner. The state didn't show anything that was an aggravating factor. There was no evidence of substance abuse. There was no evidence of prior abuse. There wasn't any evidence presented of her repeatedly leaving the child in the car before. So, Your Honor, we argue that there's no evidence of her doing a conscious act or doing a reckless act that would put the child in danger. And without one of those acts, without some aggravating factor, the state cannot reach the level of culpable negligence.
Okay, is this case appeal still pending?
This case here is actually, this case was an order granting a motion to dismiss, and I don't believe the state tried to appeal the motion to dismiss. I put this into the record specifically because it does probably the best job I have seen analyzing all of the case law around culpable negligence, particularly when it comes to a child being left in the car. And one of the things that I noticed, and I thought it was strikingly similar to this case, the court ultimately concluded that the act there was, it was a single, unaggravated, and inadvertent act of negligence despite the tragic consequence. The admitted facts are insufficient to support the offense of manslaughter by culpable negligence. And essentially in this case, it was a mother who had taken her, she had two children, each went to separate schools. She took one child to school and she forgot to take the other one and drop it off to daycare. She went to work and she went about her day. She even received a call about the child from her partner, I guess it was her former partner, and they discussed the child. And it wasn't until she actually went out to lunch to go leave that she realized that the child was in the car, and the child unfortunately had passed away. And the court in that case found that essentially the act of negligence of leaving a child in a car is one of simple negligence. And the court also found that because of the way that memory works, that the amount of time isn't really an issue. When you forget something, you forget something. There's no way you can control when you're going to remember. Now, maybe there's something that cues you to remember that, but people forget things all the time. I mean, I might drive down to my driveway with the intent to go get my garbage can, and then drive all the way to work and realize I didn't do it. But then I might not realize that until I get home and I see it in the driveway.
Okay, thank you. Anything further from the state?
Your Honor, I believe this case, first off, this is a circuit court case, and it is a motion to dismiss, and it's a trial case. I would say this case is distinguishable because we have Tracey Nix was the sole caretaker of a sole child that she spent all day with, or all lunch with. And the facts as far as what she did and providing all that care and all that time with her at vehicle Brady's and getting in that vehicle, going home, and just thinking about other things other than that child, Your Honor, I believe it's distinguishable from this matter because in this case that the defense has cited, once again, this circuit court case deals with a person taking care of two children being distracted by one and the other. She had no other distractions. Her only responsibility was to this child. Only responsibility. And she provided that and then stopped. And I think that's different here, along with the other factors that are present there. It's not just those two things, but I'm just pointing out that which makes it distinguishable from the case that the defense is trying to present to the court. And once again, this is a motion to dismiss, not a trial case in which the question was whether or not there's a prima facie case.
All right, based upon the evidence that I've seen, the evidence, the 64, 65 items, and the testimony, the state's presented a prima facie case, JOA is denied. Same rule. Second, the argument, if any, from the defense.
Your Honor, on count two, we will reserve our objection to the jury instruction on count two. We're not making an argument for a motion for judgment of acquittal on count two at this time.
All right, so there's no judgment of acquittal, so there's no reason for me to rule on it. All right, defense, are you ready to present your case?
Yes, Your Honor.
All right, jury.
Yes, Your Honor.
Ready, Judge?
Yes, Freeman.
All rise.
All right, members of the jury have a seat. Defense, please present your case.
They call me Nix, Your Honor.
Mr. Nix.
Commissioner Nix, just going to swear you in, sir.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Can you step this way, sir?
Sir, have a seat.
May it please the court.
Yes, sir, go ahead. Mr. President. Thank you.
State your name for the jury, please.
None, nay, Nix.
And Mr. Nix, you're the father of Kayla Nix.
Yes, sir.
You're the father of Rebecca Tucker,
Yes.
and you're the husband of Mrs. Nix.
Yes, sir.
Okay. All right. And obviously you remember Uri.
Yes, sir.
Okay. How often would you and or Tracey keep Uri?
Depending on the week, anywhere from 2 to 5 days.
Okay. Can you give we'll say a normal routine on how that would occur, the pickup and the delivery?
Most often would be me going to their office to pick up the child. And then I would bring her back to the house. And that's where usually Tracey would pick up.
Would pick up from there?
Yes.
Okay. And when you would drive to pick up Uri, what vehicle would you drive normally?
Normally was my truck,
Normally.
pickup truck. Yes.
Did you ever drive the red Lexus?
Yes, sir.
Okay. And in the evening, how would she get, we'll say, redelivered to her parents?
Normally was her father, Drew, would normally come by after work.
Okay. And on occasion, did you drive the Lexus
Yes.
to either pick up or redeliver
Pick up.
the child? Okay. And when you had the mirror adjusted to the back, were you able to see the car seat from the back seat, driver's side?
No, sir, not for me.
Okay. Now you're a little taller than Tracey.
Yes.
Okay. Can you tell us, would Tracey be able to, from her viewpoint, from what you saw in the Lexus?
Judge, it's speculation.
Sustained.
If you're looking out the back window from the rear view mirror, is your view going to be the same as hers if it's properly adjusted?
Yes.
Okay. And did you ever, we'll say, have a situation where you got into the car and it was adjusted for Tracey?
Yes.
And y'all have some issues about that sometime?
Some minor discussion.
Okay. All right. Thank you.
State, any cross?
Briefly, Your Honor.
Mr. Nix, I just have a few questions for you. As far as the vehicle, the Lexus, it has windows, right?
Yes.
You can see through those windows?
Yes.
No further questions.
All right, redirect.
Yes. On the day in question, could you see through those windows?
Yes.
And on the day in question, before Uri was found in the back seat, were you near that vehicle on your lawnmower?
Yes.
And could you look into the vehicle?
Not from where I was seated on the lawnmower
Okay, and why was that?
because I was located a small distance from the car at approximately the same height as the driver.
Okay, and you could not see the child?
No.
Okay, thank you.
All right, he may be excused. Fletcher, may he be excused?
Yes, Your Honor.
Okay.
Yes, Your Honor.
Thank you, Mr. Nix. State, defense call, second witness.
It's rest, Your Honor.
Okay, let's, come to a sidebar with the court, please. Members of the jury, we're going to take a brief recess. I've got to attend some business with the lawyers, so it may be around about 25 minutes. So please take your time to get your cars, do what you need to do, but please be back in about 20 minutes.
All rise. May be seated.
All right, everyone have a seat. Defense, do you have any motions you need to make? Do you have any motions you need to make, defense?
Yes, sir, renew our motion for judgment of acquittal made it into the state's case.
All right, same ruling is not, I'm sorry.
With a further caveat that verdict in this case will be against the weight of the evidence.
All right, with that, it's still denied unless the state wants me to go over any other argument.
No, Your Honor, stick with your line of previous argument.
Okay, let's bring Ms. Nix up here. Let's get her sworn in. I'd like her on the stand, please. You want to stand? You want to stand? Get Ms. Nix sworn in, please.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? I do.
All right, Ms. Nix, have a seat. All right, so Ms. Nix, state your name for the record.
Tracey Ann Howard Nix.
Okay, this is a criminal trial brought by the state of Florida versus Tracey Nix, CF 22-289 Hardy County. You're the defendant in this action, and you've chosen not to testify. Is that correct?
Yes,
Is that of your own free will and volition?
it's on my lawyer's judgment.
Okay, so you're relying upon your lawyer's judgment not to testify.
Correct.
And you understand you have the independent right to override that judgment and to testify. Yes or no?
Yes,
So you understand that this is your ship and you're the captain of it. And you can testify if you so choose to, but you're relying upon the advice of your attorney. You're saying not to testify.
yes,
But it's your decision to make individually.
yes,
And you're still choosing not to testify.
yes.
Based on the hesitation, I'd like to take a short conference with Mrs. Nix.
Okay, let's have a brief conference with Mrs. Nix.
Can we go outside?
You can go outside, yes. And Ms. Nix, just have a seat. You're back on record, Mr. Fletcher. Did you have sufficient time to consult with your client?
Yes, sir.
Is it still her intent not to testify?
That's correct, John.
All right, so Ms. Nix, you had a conference with your attorney outside, and it's your intent not to testify.
That is correct.
Has anyone forced you not to testify?
No, sir.
Has anyone promised you anything other, well, to get you not to testify?
No, sir.
You understand you have the right to take the stand to testify.
I do.
You understand that decision is totally up to you to testify or not, since it's your decision.
I do understand.
And whether you testify or not, that's in your sole mind, and it's not based upon what your lawyers are telling you or not telling you. That's your personal decision.
That's correct.
And you understand lawyers give advice. If you choose to testify, then the state will cross-examine, and you will have your waived your right to remain silent and will testify on your own behalf, just as any other witness.
Yes, sir.
All right, with that being said, I find she knowingly and intelligently has waived her right to testify and will be sitting at council table. And go ahead and speak. Let's take our 20-plus minute break. State when you get everything together, please make sure we have everything with sufficient copies and things that we need to. So we're gonna go right into, let me double check. I'm gonna give a closing argument. Y'all do your closings, and then I'll go right into the final instructions and things.
Yes, Your Honor, and just so make sure the state understands, you would like obviously copies of the instructions for Your Honor, correct, 6 for the jury.
Correct. 6 for the jury.
The redacted information to go back with the jury and one for you to read.
Correct. And then the verdict form, you'll have a copy of the verdict form and the instructions, but then I get a separate copy to put down for the clerk. Anything on that clerk's table, defense and plaintiff and state need to make sure y'all have gone through it, because it's going back. I don't want to hear, oh my gosh, we forgot the word insurance or something like that, like I've heard in the past. So we're gonna, what's on that table in front of that clerk is going back to that jury. All right.
Yes, Your Honor.
All right. Defense, anything?
No, Your Honor.
All right. We're adjourned for 20-plus minutes.
All rise. So we recess until 10 minutes to see a video is interesting.
312. The verdict form is included thereafter. We, the jury, finds count one, defendant Tracey Nix is guilty of aggravated manslaughter of a child, or the defendant Tracey Nix is guilty of manslaughter or lesser included offense on count one, or Tracey Nix is not guilty. We, the jury, finds count two, defendant Tracey Nix is guilty of leaving a child in a motor vehicle in excess of 15 minutes causing great bodily harm, or the defendant is guilty of leaving a child in a motor vehicle in excess of 15 minutes. The lesser included offense of count one, or defendant Tracey Nix is not guilty. So say we all this blank day of January 2025, four-person print name, single defendant, multiple counts, 312A, 313, submitting case to the jury. 4-1 and 4-2 are reserved for the appropriate times. Defense, you agree with these jury instructions subject to prior objections?
I'm just looking, double checking before we go. There's something on 3.12, I'm just not certain that I want to discuss.
Take your time. When you have a separate verdict form, Brian, we need to make one. Did you give me a separate verdict form?
Your information that you requested?
Yeah.
Okay.
Let me look at the information, and let me look at the information in separate verdict form. Thank you. I apologize.
There's your information and the copy to go back to the jury. It has been redacted as far as level and degree.
Okay, so the information is in the Circuit Court, 10th Judicial Circuit, Hardin County, State versus Tracey Howard Nix, 22 CF 289. Aggravated manslaughter of a child, count one. Brian Haas, State Attorney, bond through his undersigned Assistant State Attorney, charges Tracey Howard Nix on or about November 1, 2022, in the County of Hardin, the State of Florida, willfully or by culpable negligence did fail or omit to provide Uriel Schock, a child with the care, supervision, and services necessary to maintain the child's physical and mental health. The prudent person would consider essential for the well-being of the child, and said Tracey Howard Nix was the child's parent, adult household member, or other person responsible for the child's welfare, and as a result of said culpable negligence, Tracey Howard Nix caused the death of Uriel Schock and or caused great bodily harm, permanent disability, or permanent disfigurement of Uriel Schock, contrary to Florida Statute 782.07, 827.03. Count two. Informant aforesaid under oath, further information makes that Tracey Howard Nix on or about November 1, 2022, in the County of Hardin, in the State of Florida, being the parent, legal guardian, or other person responsible for Uriel Schock, a child younger than 6 years of age, did leave said child unattended or unsupervised in a motor vehicle for a period in excess of 15 minutes, and in doing so caused great bodily harm, permanent disfigurement, permanent disability, or permanent disfigurement to Uriel Schock, contrary to Florida Statute 316.635. There's nothing telling what degree of felonies these are. They appear to be redacted. Do you agree to offense?
Yes, Your Honor.
All right, there you go. And I need a good back to the jury. Do I have a verdict form?
Yes, Your Honor. I also, there was one provided in the instructions, but
There's one, I'd like a separate one.
I did the separate one for you and the jury.
Hold on. All right, the verdict form is as I read it earlier. Could you please put a paperclip on that, put it with the information? That'll go back to the jury.
Your Honor, I have reviewed the verdict form and the defense accepts the verdict form. I have reviewed the jury instructions. There was one minor thing, I think it was in 3.12, that I asked the state if they could correct it. It appears to be an error.
What is it?
Your Honor, in the language, in the language as far as whether or not you can find someone guilty of various lessers, there are certain crimes in which you can be found guilty of multiple lessers, and that language was accidentally included in there. I've deleted it, I've printed it, I have someone from my office bringing it up. It'll be here before you start to read.
Yeah, so basically it's a replace 312 with what you're gonna get.
Exactly.
Okay, so do you want my clerk from Hardy to replace, or do you want to replace?
Whatever I'm assuming it's gonna be brought up here momentarily, and I can do it, or the clerk will do it.
All right, clerk, you want to do it, or you want the state to replace? All right, state's gonna replace. Thank you.
Yes, Your Honor.
Your Honor, defense has reviewed the jury instructions other than the previous previous objections that we made, we find the jury instructions acceptable.
Thank you. Okay. Second page. State, you gave us 2 front pages on the verdict form, just give me the back page, please.
Oh, I apologize. Your Honor.
No problem. Give them back the front page. Take a look at that. It's in the package that way, but I'll have to give it a second. So for the record, state and defense, come on up here. And the bailiff, come over here. With the court report. Let me go ahead and have my copy of that. Give it to defense. Sidebar. Two things. Look at the jurors.
Oh, 1 second, Your Honor. Did you want me to replace these now?
Oh, yeah, great, put them in. When you're done, you tell the bailiff and the bailiff.
It'll only take a moment. Luckily, my person downstairs is incredibly fast. Deal. Excellent. Appreciate you.
For the record, I'm also going to read when I charge the jury, defense number 5, instruction.
Sorry, Your Honor. Yeah, I thought you saw. Yes, the state is
The state has completed replacing the bench.
Judge, you good? All right, let's bring the jury in. All right. Are you on? Yes, bring them in, please.
All rise.
All right, everyone have a seat, please. Members of the jury, we're at a break. Has anybody discussed this case or has anybody heard anything about this case while on the break? Please raise your hand if you've heard it or discussed anything. All right, seeing no hands are raised, we're going to go into closing arguments. Both the state and the defendant have now rested their case. The attorneys will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. State, you prepared?
Yes, Your Honor. Please, the court.
Go ahead, Mr. Coleman.
Counsel.
Yes, Your Honor.
She just hurt herself, and she just boiled to death.
Members of the jury, as we go through our lives, one of the early lessons we get is everybody makes mistakes. Most of the time, we apologize, we accept responsibility, and we move on. Unfortunately, some of us in this room might have learned sometimes sorry is enough for those mistakes. Sometimes those mistakes carry dire consequences, and sometimes those mistakes are crimes. And that's why we're here today. And I would argue to you that is why the legislature of the state of Florida passed the very laws we're here today that the defendant is accused of. So in order to discuss this case, to discuss the facts, what's important first is that we discuss what I believe you're going to be instructed on as far as the law related to this case is. You will receive copies of these, so please, you don't have to write furiously. What I believe the judge is going to tell you is to prove the crime of aggravated manslaughter, the state must prove the following three elements beyond a reasonable doubt. 1, Uriel Schock is dead. 2, the death of Uriel was caused by the culpable negligence of Tracey Nix. 3, Uriel was at the time a child, and Uriel's death was caused by the neglect of Tracey Nix, a caregiver for Uriel. Now, I just want to get out in front of it and just tell you, I believe the crux of this case, what everybody's going to be talking about, what you yourselves are going to be talking about, is number 2. Culpable negligence. What is it? So, but it is my job, it is my burden as a state to prove the crimes. And even though 1 and 3 are not in dispute, we're going to talk about it, get those out of the way, and move on to the crux of the case. So, 1, Uriel Schock. is dead. The court instructed you, we've agreed. The parties have agreed. She's dead. That's not an issue. Skip to 3. Uri was at the time a child. Once again, that's not in question. She was 7 months. And her death was caused by the neglect of Tracey Nix, a caregiver for Uriel Schock. Was caused by the neglect. So just from that point, just neglect. She left her in that car. That's not in dispute. What's in dispute is whether or not it's culpable negligence. There's no dispute on whether or not it's neglect. A caregiver, there's no question. As the judge will inform you, a caregiver means a parent, adult household member, or any other person responsible for the child's welfare. She was Uri's grandma. She was the sole caregiver at that time for Uri. Uri was solely dependent on her for care. So I would argue to you, members of the jury, that 1 and 3 are not in dispute. So let's talk about 2. Before we get there, there's this language that we're going to get to in culpable negligence that may be confusing, but it's clarified by what the judge is going to instruct you on what neglect of a child means. It means a caregiver's failure or omission to provide a child with the care, supervision, and services necessary to maintain the child's physical and mental health, including but not limited to, for the well-being of the child. Here's the thing. Neglect may be based on repeated conduct or a single incident. Repeated conduct or a single incident, or omission by that caregiver. They didn't do something. So I want you to keep that in mind, please. So we'll turn to it. The death of Uriel Schock was caused by the culpable negligence of Tracey Nix. Remember, it could be a single incident. I anticipate the judge is going to tell you that aggravated manslaughter, he's going to tell you that first, every person has a duty to act reasonably towards others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence, simple negligence. So it's interesting, and I want to discuss that for a moment before we go on. How are you given the definition of culpable negligence? We define simple negligence. Culpable negligence is, you can have negligence, but it can become more based on the facts and circumstances. It's important. The definition of culpable negligence is started by giving you the definition of simple negligence. The defendant cannot be guilty of aggravated manslaughter by causing the death merely from a negligent act. But culpable negligence is more than the failure to use ordinary care. In order for the negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing a reckless disregard for human life or the safety of persons exposed to its dangerous effects. See, that course of conduct is one way. Or safety of persons exposed to its dangerous effects. Safety of persons exposed to being left in a hot vehicle. It fits there. It fits there. Or shows wantonness or recklessness. Or grossly careless disregard for the safety and the welfare of the public, or indifference to the rights of others. The negligent act or omission must have been committed with utter disregard for safety of others. That's what we're talking about here. Those are the types of things that we're talking about. So when we start to talk about culpable negligence and what it is, that definition, I think, sets the stage of how you're to analyze. First, was there negligence? Second, was that culpable negligence? Follow that definition. So how do we determine what culpable negligence is? We just don't look at the act. We look at everything surrounding that act and the results of that act. That's what gives you culpability. That's what gives you criminal negligence. So in order to discuss that and have a conversation about that, I think we just need to go through briefly a rough timeline. We don't have anything set in stone, but we have good witnesses who testified, and we have an idea of exactly what happened that day. Around 9:30 to 11 a.m., there was some testimony, it might have been 10. Regardless, there was that prayer meeting.
We heard from the two nice night ladies, Judy Terrell, the defendant herself. That's where she started out that day. Sometime between 11 and 12, she agreed to pick, she being the defendant, agreed to pick up Uriel that day. We know that she talked with Taylor. She at least messaged, and we do see on her phone around 11:18 that there was a conversation. Sometime between, and at that meeting is when they have from the prayer meeting from 9:30 to 11, lunch is discussed. We're going to meet at these. The agreement to pick up Uriel, I pick her up first. That's Gail goes along with her. Sometime between 12 and 12:30, we know from the time she had a beef, she got there around 12:30. Between 12 and 12:30, she picks up Uriel. When she goes and gets Uriel, she gets a diaper bag with the supplies. She gets everything she needs to provide the care a responsible caregiver would give to that child. She picks that up. She also picks up a car seat and places it in her back seat. Once again, a responsible caregiver. She's provided all of these tools to do what she needs to do. So she gets that car seat, places it in the back seat of her car. 12:30 to 1:45 is roughly about the time that there are beeps. You saw the video, a portion of it. It's all there for you to review when you go back there if you choose to. We know around, it's that 1:45-ish area that she left, because one, we know from all the three ladies that were with her, Gail had to be out of there. And they know, they looked at their watch, and it was 1:40 when they started leaving. And we see on the beef's been injured from that point. But there is no doubt that more than 15 minutes elapsed. And in doing so, Tracey Nix caused great bodily harm to Uriel. What greater bodily harm is there than death? That's all the time I'm going to spend on that count. I believe that count. It's unequivocal. It's there. So let's focus more on her actions. Let's talk about culpable negligence. Let's talk about wanton and reckless. We have to look at those circumstances surrounding. It's easy to say, oh, she just forgot. That's simple negligence. Well, that's the only way. If she did it on purpose, she'd be charged with murder. We charged her with culpable negligence. So yes, forgetting something is simple negligence. Forgetting to lock your door when you leave your house, simple negligence. Forgetting to take the food out of the stove, simple negligence. Maybe even forgetting that you were the parent that was supposed to pick up the child who's safe at school, but has to wait another 10 or 15 minutes because you forgot. Simple negligence. Leaving a child unattended in a car for 3 hours in the hot Florida sun baking. That's not simple. No matter how you slice it, that is not simple. Uriel's death was not simple. Let's talk about that. We have to look at those facts and circumstances. It's not just the forgetting, but we have to look at what her duty was that day. She was the sole person responsible for the most vulnerable thing we have in our society as human beings. A baby. A baby. You have a heightened duty. You're in charge of something that literally can't live without you. She can't open that car door. She can't even get herself out of that car seat. She can do nothing to protect herself. She relies on someone to do it for her. She relies on a responsible person who keeps her first in her mind, who knows her duty, who knows this is a great responsibility. And we know that she knew that, and we'll talk about that in a minute, because she did that earlier. But she just got back to the house. I'm home. Let me do what I need to do. Uriel deserved to be the primary focus in her mind that day. But she wasn't. And that goes towards the culpability. That goes towards the criminality of her negligence. That's why this happened. You have, when she is in your possession, she is your focus. She should be the first thing on your mind. Now,
Let's continue our discussion about the facts. She picked up Uri. Now, I know it was something that she wasn't expecting to do, but she did. She picked her up. She went and she got the diaper bag, she got the car seat, she got these, as I said earlier, were the supplies to ensure this child's safety. Members of the jury, the diaper bag was entered into evidence. And all those supplies are still in here. And you could feel the weight almost as much as Uri herself. She had everything she needed to protect her, to care for her, to ensure her survival. She had a car seat. She had everything she needed. She's the one who put it in there. At this point, Uri should be the only thing on her mind. Uri should be the primary focus on her mind. Again, the diaper bag. We can see the supplies, the bottles to feed her, the clothes to clothe her, the medications to give her. You can just see the volume of stuff that she had. Again, why do I show you all these things? These are the things that should push Uri to the forefront, that should make her the priority. The car seat placed in her vehicle. She's there. She's there. And what did she do when she went there? She didn't just immediately go home and say, oh, I forgot I had her. She went to lunch for an hour. Let's talk about that. The time it needs. She's over there. She's there for over 1 hour. She comes to the restaurant. She didn't leave Uri in the car then. Uri's with her. She brought in the diaper bag. And as a matter of fact, you see constant attention's on Uri. As a matter of fact, Uri was not only the center of attention for the defendant, she was the center of attention for everybody there. There's something innate in human beings. When you see an infant like that, there's just a need to protect, a need to pay attention. And you could see that in the people around her. You could see that in the defendant herself. So why is this important? As I stated earlier, there she is. On her lap. The focus of her attention. Oh, she almost pushed off the bottle. Again, this is the thing that should be reinforcing in this caregiver mind, in this caregiver's mind. This is something I need to protect. This is something I need to look out for. Then she left these. She took Uri with her, didn't leave her in the restaurant, took her with her. Put her in the car seat. You can see the blanket over her shoulder. She brought everything out, didn't leave anything behind there. Took the diaper bag. And then what'd she do? Drove straight home. And we saw her when she was leaving these. There she is. Diaper bag, white blanket, baby in hand, even the food. Didn't leave the food behind, had a friend bring it. There it is. Being placed right in the vehicle, Uri in the car seat. She knows she has Uri. She knew it. She placed her in that car seat herself. That's right behind her driver's seat. She's driving an SUV, but it's not one of those giant SUVs. It's not a Hummer. It's a small vehicle. She put the diaper bag in there. She put the blanket in there. All these things. And then where'd she go?
Was it just you and Uriel on the phone? And about when you got back to the house, did you make any stops in between?
No stops in between, straight home. Straight home from spending an hour at lunch, fawning over little Uri. Didn't make any stops, no interruptions in between. Straight home. And what did she do when she got home? Well, parked her car, got out of her car, closed the door, and went about her business. What kinds of things would she do?
I practiced for a long time. I can't believe I didn't even think.
So you went straight home and you started talking to your dog? Okay. And what's your dog's name again? Macy.
So what is she doing? She goes home, gets out of the vehicle, got to go talk to the dog. Got to go practice my piano. I'm working hard at it. As I said, got out of the car. Meanwhile, Uri's left in that vehicle on a hot Florida 90-degree day. 3 hours. What is she doing in that 3 hours?
And when you went inside after getting home, what did you do?
I went and started practicing the piano. I think lessons that I have one on Thursday and I need to just put in time on it.
Okay.
She's practicing her piano, and Uri's body is fighting the heat.
I was thinking my other grandson was supposed to take it out for dinner.
Okay.
And I was impatient because they were about an hour behind. And I finally got in the car and went down to the barn because they had to go feed the pig, 4-H pig. And all of a sudden, when I got out of the car, it came across my head that I had Uriel and what happened. It came to pick her up and couldn't remember what happened.
She was more focused on her meeting that she had planned with her grandson than the 7-month-old whose body was fighting the heat in the car while she was thinking about all this stuff. Didn't even dawn on her.
Now, just so I understand correctly, Ms. Tracy, you said that you were gonna get your other grandson for dinner. Okay.
That had been planned for several days.
Again, that's the thing that is more important to her at the time that she's thinking about. Getting out, taking care of the dog, playing the piano for an hour. Plans that she had made the day before, ignoring the plan that she had made that day and that obligation that she made that day to protect that child.
After 4:30, got in the car so that I would be there when they were feeding the pigs, when you know.
She actually got back into the car to go feed the pigs. Got back into the car where Uri, at 4:30, where Uri's been now for 2.5 hours on her own. Still, nothing.
About how long after 4:30 did you realize that she was in the car?
When that talk today, probably 5 to 10 minutes,
Okay.
with him sitting on the mower and me sitting in the car. And then I got out because Rebecca.
Toward others. And this is what the judge is going to read to you. If there's a violation of that duty without any conscious intent to harm, that violation is negligence. That's what we have. Read it again. Every person has a duty to act reasonably toward others. If there's a violation of that duty without any conscious intent to harm, that violation is negligence. Conscious. Where have they shown you anywhere that Tracey Nix consciously did this? Now, this is culpable negligence. The defendant cannot be guilty of aggravated manslaughter by causing a death because of a merely negligent act. She forgot. That's the act. That's not culpable negligence. Forgetting. It's more than a failure to use ordinary care toward others. In order for it to be culpable, it must be gross and flagrant. Again, separate the act from what actually the result was. You have to separate the two. It's got to be gross and flagrant. She forgot. She simply forgot. Grandma forgot. Culpable negligence is a course of conduct showing reckless disregard of human life. Do you think she intentionally left this child in this car? Can you possibly, after seeing those videos, even think for a second that she intentionally and recklessly left this kid in this car? She forgot. Simple negligence, ladies and gentlemen. Now I'm just reading the jury instruction. Culpable negligence is a reckless disregard of human life or the safety of persons exposed to its dangerous effects, or an entire want of care as to raise a presumption of conscious indifference to the consequences. Do you think for a second that she had a conscious indifference to the consequences? Again, she forgot. The results are horrendous. That's a separate element. They have to prove culpable negligence, and they can't do it. They can put on diaper bags. They can put on this timeline. They can put on this video from Beef O'Brady's, but none of that shows culpable negligence. This is extremely high burden of proof that they have to prove beyond a reasonable doubt. Continuing. Wantonness or recklessness, grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of rights. Did they come anywhere close to showing any type of intentional violation of rights? It has to be tantamount or equivalent to an intentional violation of rights. Culpable negligence is consciously, and again, I'm continuing reading the jury instruction. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. This is replete with gross, flagrant, conscious disregard. There's nothing here to show that. They've shown simple negligence. Again, every person has a duty to act reasonably toward others. If there's a violation of that duty without any conscious intent to harm, that violation is negligence. Again, that's what we have. These are very serious charges. I ask you to deliberate, read these instructions at 7.7a, and look at the definition of culpable negligence. They have not proven it. The whole issue here, again, is culpable negligence, and she forgot when she got home. And you say, well, why did she forget? I don't know. The brain's a strange thing. Why did she forget? Was it age? Distractions? They had the roofers there that day. You had other plans. But again, she simply forgot. She simply forgot. And when she remembered, well, you saw what happened when she remembered. You know, Tracey Nix has to live with this forever too, carry that burden for what happened that day. But again, it was simple negligence. When you forget, you forget. And when you remember, why do you remember again? Now, I'm sure every one of you, regardless of your age, has had an incident or a number of incidents where you're supposed to pick up something or somebody on the way to work, and you get to work. You're supposed to pick up something at the grocery store on the way home. You forget. It's simple negligence. It was simple negligence here. The state was wrong when they said that there's a higher duty when it's a child. That's number 3. That's not number 2. There's nothing in culpable negligence that talks about babies as opposed to anybody else. You have to look at that. The actions of Mrs. Nix. The actions, not the results. There's nothing we can do to bring this child back, ladies and gentlemen. And again, I urge you to look at the definition. Again, he's taking simple facts. He's turning that into culpable negligence. And please don't make this terrible situation worse by convicting Tracey Nix of something that she's not guilty of. Thank you.
Thank you, Professor State.
I started out when I spoke with you folks, discussing mistakes, and sometimes sorry isn't enough. And I would argue that the judge is going to instruct you on something that agrees with me. The court's going to instruct you that this case must not be decided because you're for or against it, because you feel sorry for anyone or are angry with anyone. And I agree with that. No matter which side, we're human beings. I apologize to you, the jury, because we asked you to do something impossible, which is set aside what makes you human, your emotions, but you have to do it. And I stress, and I would agree, and I would echo, look at those facts. Those facts reveal the truth. Those facts reveal the crime. Don't make that decision because you sympathize with her. Don't make that decision because you're angry at her. Make that decision because she did it. That's what you need to make your decision on. I do want to spend a few moments of my time addressing some of the things that the defense said. Uri, she isn't milk. She isn't groceries. She isn't an unlocked door. She isn't the pet you forgot to walk. She was a 7-month-old baby. And yes, you have to consider that when you consider whether something's reckless. What would a reasonable person who's in charge of a 7-month-old, who is responsible for her life, her survival, what would they do in that situation? The defense wants you to take the simple act of forgetting and focus on that and say, you can't look at the results. You can't look at the other factors. No, members of the jury, you have to. That is what tells you whether a simple mistake, simple negligence is reckless and wrong. And I would argue to you, members of the jury, that it is here today. She should not have forgotten about that child. She spent all that time with that child. Defense points out, well, I can't believe we showed you the video. Yeah, we showed you the video because that Tracey Nix that was at Keith O'Grady's should have been the Tracey Nix that got out of the car, but it wasn't. She was more focused on other stuff she wanted to do when she got home that she completely forgot about her. Not for 15 minutes, not for a half hour, not for 45 minutes, not for an hour, not for 90 minutes, not for 120 minutes, for almost 3 hours. Is that something a reasonable caregiver would do? Or is that something that's gross and flagrant and wanton and reckless? The act of leaving the child in the car, I don't think anyone would argue. If she, again, like I said, if she intended to leave that kid in that car and Uri was trapped in there, she would be charged with a very different crime. We're talking about, it can be confusing, we're talking about negligence. She doesn't have to have the intent to hurt Uri, but her actions did anyway. That's what we have to look at. It's a difficult case, members. It's a difficult crime. It's a difficult law. It is. But the facts are there. And once again, I need to remind you, she is not stepping on someone's foot. She is not leaving your eggs in the car overnight. She is a child. Defense counsel keyed in on a word, and there is a word in the culpable negligence instruction, conscious, and that throws people off. Conscious as opposed to unconscious. That's what that is. She was conscious the entire time. She should have known. She should not have forgotten. She had no reason to forget other than there were things more important, like playing the piano, taking care of the dog, feeding the pigs, finding her husband, those types of things. And defense counsel wants to talk about distractions. Well, from what we saw at Beef O'Grady's, she deals well with distractions.
There were a lot of distractions around her. Everyone came up to see that day. But she didn't forget Uriel. She didn't forget that. She took care of her. She did everything she was supposed to do. Unfortunately, Beef O'Brady's Tracey Nix stayed there. What came home was the one who committed criminal negligence. At the end of the day, members of the jury, I think you have to look at all the facts and circumstances, not just the forgetting, but all of the surrounding circumstances. And you have to look at that and say, what would a reasonable person in that situation do? What would a reasonable person who is responsible for the care and safety of a 7-month-old infant do? And I would argue to you, it would be remember. Don't forget. Don't leave. Be focused on her. Make sure she's okay. She's your little granddaughter. Care for her. Protect her. Get her out of the car. And a failure to do that, members of the jury, that's a mistake. That's criminal. That's a mistake. That's culpable. That's a mistake. That's the crime of aggravated manslaughter. That's the mistake that she needs to be held accountable for under the law. And you need to go back in that jury room and convict her. Thank you.
Thank you. Do you want to close your screen down?
Yes, sir.
Please. All right, members of the jury, I want to thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. We're going to hand you each a copy of the instructions. Please go ahead and do that. Madam Clerk, move that. You'll be able to take these instructions to the jury room with you. You'll have a verdict form. You'll also have information with the appropriate information. Statement of the charge. Tracey Howard Nix, the defendant in this case, has been accused of aggravated manslaughter of a child and leaving a child in a motor vehicle in excess of 15 minutes, causing great bodily harm. You'll have an information that shows the charges and the statutes. I won't read it to you because y'all all can read it when you get back there. That's fine right now. We'll be fine with just what we have here. Aggravated manslaughter in Florida is to prove the crime of aggravated manslaughter. The state must prove the following 3 elements beyond a reasonable doubt. Uriel Jane Schock is dead. The death of Uriel Jane Schock was caused by the culpable negligence of Tracey Howard Nix. Uriel Jane Schock was at the time a child, and Uriel Jane Schock's death was caused by the neglect of Tracey Howard Nix, a caregiver for Uriel Jane Schock. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of aggravated manslaughter by causing a death because of a merely negligent act. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life and of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. The defendant cannot be guilty of aggravated manslaughter if the killing was either justifiable or excusable homicide. I'm not going to instruct on that because we do not have that here. I'm going to tell you to exclude that off of these instructions. Child means any person under the age of 18 years. Caregiver means a parent, adult household member, or any other person responsible for a child's welfare. Neglect of a child means a caregiver's failure or omission to provide a child with the care, supervision, and services necessary to maintain a child's physical and mental health, including, but not not limited to food, nutrition, clothing, shelter, supervision, medicine, and medical services that a prudent person would consider essential for the well-being of the child. Neglect may be based on repeated conduct or on a single incident or omission by a caregiver that results in or could reasonably be expected to result in serious physical or psychological or mental injury or a substantial risk of death to the child. Leaving a child unattended or unsupervised in a motor vehicle causing great bodily harm. To prove the crime of leaving a child unattended or unsupervised in a motor vehicle causing great bodily harm, the state must prove the following 4 elements beyond a reasonable doubt. Number 1, Tracey Nix was a person responsible for Uriel Schock. Number 2, Uriel Schock was younger than 6 years of age. Number 3, Tracey Howard Nix left Uriel Schock unattended or unsupervised in a motor vehicle for a period in excess of 15 minutes or for any period of time if the health of the child was in danger. 4, in doing so, Tracey Howard Nix caused great bodily harm to Uriel Schock. Motor vehicle means a self-propelled vehicle not operated upon rails or guideway, but not a bicycle, electric bicycle, motorized scooter, electric personal assisted mobility device, mobile carrier, personal device, swamp buggy, or moped. Vehicle means every device in, upon, or by which any person or property is or may be transported or drawn upon a highway. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. When there are lesser included crimes or attempt, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which she is accused, there may be evidence that she committed other acts that would constitute a lesser included crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of a lesser included crime. The lesser included crimes indicated in the definition of aggravated manslaughter of a child is manslaughter. The lesser crimes included in the definition of leaving a child in a motor vehicle in excess of 15 minutes causing great bodily harm is leaving a child in a motor vehicle in excess of 15 minutes. Manslaughter. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Uriel Schock is dead. And number 2, the death of Uriel Schock was caused by the culpable negligence of Tracey Howard Nix. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violence is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. Leaving a child unattended or unsupervised in a motor vehicle. To prove the crime of leaving a child unattended or unsupervised in a motor vehicle causing great bodily harm, the state must prove the following 4 elements beyond a reasonable doubt. Number 1, Tracey Howard Nix was a person responsible for Uriel Schock. Number 2, Uriel Schock was a child younger than 6 years of age. And number 3, Tracey Howard Nix left Uriel Schock unattended or unsupervised in a motor vehicle for a period in excess of 15 minutes or for any period of time if the health of the child was in danger. Motor vehicle means a self-propelled vehicle not operated upon rails or driveway. Vehicle means every device in, upon, or which by any person or property is or may be transported or drawn upon a highway. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial, and to it alone, that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Throughout your deliberations, you may discuss with each other the evidence and the law that has been presented in the case, but you must not communicate with anyone else by any means about the case. You also cannot learn from outside sources about the case, the matters in the case, the legal issues in the case, or individuals or other entities involved in the case. This means that you may not use any electronic devices or social media such as a phone, computer, or tablet, the internet, any text or instant messaging, or any social media apps such as Twitter, Facebook, Instagram, LinkedIn, YouTube, WhatsApp, and Snapchat to research or communicate about what you've seen and heard in this courtroom. These restrictions continue during deliberations because it's essential under our Constitution that you decide the case based solely on the evidence and law presented in this courtroom. Information that you find on the internet or through social media might be incomplete, misleading, or inaccurate. And as I noted in my instructions at the start of the trial, even using your smartphone, tablets, and computers and news media and social media apps on those devices may inadvertently expose you to certain notices, such as pop-ups or advertisements that could influence your consideration of the matters you've heard about in this courtroom. You are permitted to discuss the case only with your fellow jurors during deliberations because they have seen and heard the same evidence and instructions on the law that you have. And it is important that you decide the case solely on the evidence presented during the trial without undue influence by anything or anyone outside the courtroom. For this reason, I expect you to inform me at the earliest opportunity should you learn about or share any information about this case outside of the courtroom or the jury room, or learn that another juror has done so. You will weigh the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, number one, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the testimony and other evidence in the case? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed with law enforcement does not mean that his or her testimony should be given any other weight than any other testimony. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusions about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The defendant did not testify in this matter. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in this case. The defendant's statements were introduced into evidence. A statement claimed to have been made by the defendant outside of court has been introduced into evidence. Such a statement should always be considered with caution and be weighed with great care to make sure it was freely and voluntarily made. If you conclude the defendant made the statement, you must also determine from the evidence whether this defendant's statement was freely and voluntarily made. In making this determination, you should consider the circumstances, including but not limited to, one, whether when the defendant made the statement, they had been threatened to get them to make the statement. Two, whether anyone had promised the defendant anything to get the defendant to make the statement. If you conclude the defendant's made the out-of-court statement, but it was not freely and voluntarily made, you should disregard it. Rules for deliberation. There are some general rules that apply for your discussions. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. I've read them to you. You're going to get them, take them in the back. If you fail to follow the law, the verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have learned, that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence in these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job, my job, to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions that I'm giving you and that I've read to you. That is the law. I'm going to caution y'all. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I prefer one verdict over another. When you reach a verdict, you may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It reads as follows. It's 2 pages. The first page is the count 1 and 2, and the second page is where the foreperson dates and signs it. It says, in the Circuit Court, 10th Judicial Circuit of Florida, NN4, Hardy County, State of Florida versus Tracey Nix, CF 22-289A, verdict form. We, the jury, find as follows as to count 1 of the charge. Check only 1. You check 1. The defendant, Tracey Nix, is guilty of aggravated manslaughter of a child, or the defendant, Tracey Nix, is guilty of manslaughter, a lesser included offense of count 1, or the defendant, Tracey Nix, is not guilty. You go then to count 2. We, the jury, find as follows as to the count 2 of the charge. Check only 1. The defendant, Tracey Nix, is guilty of leaving child in a motor vehicle in excess of 15 minutes causing great bodily harm, or the defendant, Tracey Nix, is guilty of leaving child in a motor vehicle in excess of 15 minutes, a lesser included offense of category 1, or the defendant, Tracey Nix, is not guilty. You go to the second page, you date it, the foreperson. So we all say this, blank day of January 2025, foreperson signs it, prints the name. A single defendant with multiple counts of information. A separate crime is charged with each count of the information, and although they have been tried together, each crime and evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. I'm going to submit the case to you as the jurors. We're going to have lunch. It's already been ordered for you. It'll be in there. You're going to have time. So in a few minutes, the bailiff's going to take you to that room. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried out in an organized way, that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on the verdict, and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another, and only when all jurors are present in the room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You're not to communicate with any person outside the jury about this case until you have reached a verdict. You must talk about this case in person or through the telephone, writing, electronic communication, such as email or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instructions I've given you in the case, you must tell me by giving a note to the bailiff. Many of you have cell phones, laptops, tablets, and other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of these types of electronic devices into the courtroom. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. Do take your notes. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk to the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. We do have a machine for y'all to go through whatever you want or don't want to see. It's going to be there. Y'all choose what you're going to see. This is your deliberation. These exhibits will be sent to the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding the verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has a right to violate the rules we all share. All right, let me speak to the lawyers for a minute on the record, and then I'm going to retire the jury. There's 2 people that are alternates, and since we're going to be going into deliberations, we no longer need the alternates. So I have jurors 1, 2, 3, 4, 5, and 6. The alternates are 7 and 8, and the chairs that they're sitting there. And you will be released. We'll allow you to go in and get your items, and the bailiff will escort you to it. You're welcome to come back into the courtroom and wait on the verdict. You're welcome to go home, do anything you'd like. Obviously, it's your choice. The trial has been live streamed, so that's your choice, what you do. All right. Let me talk to the state. Okay. All right, members of the jury, we're gonna take the jury instructions back from you, because we have to switch out a page that I read correctly, that was not in there, so we'll give you the corrected jury instructions and the corrected verdict form, is that correct?
Yes, sir.
And you'll be getting them in the back. So what I'd like to do now is we're gonna release the alternates, I've identified who they are. I'd like the jurors to go all back into the jury room, get all your personal belongings alternates, come out and the bailiff will escort you where you need to be. Don't discuss anything with each other until the alternates have left. Does everybody understand? I have one question of the jurors before I let you go back. We've talked about, have you seen or heard anything
Girl,
outside
why are you live?
through the witnesses and the evidence that you shouldn't see?
Do you know what time it is?
Papers,
Hey,
telephone
everybody.
calls, or other information. By show of hands, has anyone received any information since I asked this morning or
You'd
yesterday
have.
that causes
Hey,
you
John.
to not be a fair and impartial juror? If you do have, raise your hand, please. I see no hands raised, so y'all have adhered to my rules and you've not seen any outside media sources. All right, thank you all for your patience. All rise, we're sending the jury out at 11:25 on the record.
Just checking in, making sure y'all are behaving while Jody is asleep. Have a beeper that will go off in case of emergency or tomfoolery.
Once the jury's out, I'm going to shut the door.
There you go.
Some other matters.
Love y'all.
So have a seat. We're going to take a minute or something. Then we'll start. I need to make sure the state and the defense get everything together. Have to make sure our alternates are released, okay? And you make sure you have these 6 that are supposed to be in there, okay? You can have my sheet back.
May I have a person from the office,
Yeah.
or just a copy of the,
Brian,
yes, the court's courtesy order.
for the record, the jury is in the sequestration in the jury room. Alternates 1 and 2 have been released. The bailiffs are escorting them out. Their meal will be served.
vote, Charlie?
Sleep.
Experts for the problem.
Correct. That's fine. That's fine. Well, we'll just hold the vote. Okay, we're gonna start with your experts at 1 o'clock for problem. All right, State, are you ready for me to go over some other matters?
Oh, yeah, sure. I just wanted to know, do you think it would be easier just to remove the excess verdict forms from their copies so there's no confusion or you want all?
Just leave them all in there.
Yes, sir. We'll just have to replace them. Yes, sir.
Yeah, just leave them in there because they're already in.
Yes, sir.
I've had them pull them out and sign them, and I've had them sign the blank one. It's just paper.
Yes, Your Honor, as long as, I can,
Yeah, do that.
okay. I was saying, I could do two things at once if Your Honor wants to proceed.
Well, let me do this. Let me have the defense come up and they have a motion and we're off the record. There's no jury. I'm sorry, we're on the record. There's no jury in the courtroom. Defense, what was your concern that you raised to me at sidebar outside the presence of the jury's hearing?
That I've been notified by a reporter, I don't know who the reporter was, but a reporter and two other persons that the jury was being viewed on TV, on live stream on TV.
Today that was done?
That we received it during the closing.
Okay, all right,
That's my concern, and candidly, I've never had this happen, so
okay,
didn't know what to do other than bring it to your attention and request a mistrial.
okay. I was given a note, I was told by a bailiff that the jury, that the cameras were too far panned out, so I had the cameras panned back in. If you want to have a hearing, you call your first witness.
I don't know who to call, just
Well, there's a cameraman there, you can seek to call the cameraman, you can seek to call who. I don't have that, I have not been watching that live feed, I've been doing a live stream here, I've been reading jury instructions, it's your case, your motion, tell me how you wish to proceed.
Should I have them all?
Yes, sir. Mr. Collins.
I think we will, Judge.
You'll call the cameraman?
I don't know his name. Did you?
Okay. Sir, come on up. I'm gonna swear you in. All right, sir, just raise your right hand. Do you swear or affirm the testimony given in this case be the truth, the whole truth, nothing but the truth, so help you God? Okay, you can step back, you need to step back a little, wherever you like, or if you want to witness. I just.
Whatever's more comfortable for him.
I'd assume you just be back a little bit. Yeah, but, yeah.
Sir, and I apologize. I
State your name, sir.
Eugene Perry.
Okay, you're the cameraman that was manning the camera.
Yes.
Okay, go ahead, Mr. Fletcher, and if there's an inappropriate question, state can object, or I'll stop the question. All right, go ahead.
You were the cameraman during the closing argument?
Yes.
All right. Did you, for whatever accidentally or intentionally, view the jury on the camera?
Objection,
don't know.
calm down.
I don't know. If I did, it was a flash of me moving from one shot to another one. I have never just sat on the jury. So if I have a shot on my video of that, it'll be while the camera is actually moving to somewhere.
Is it,
Across maybe, but
is it difficult?
I didn't see, I haven't seen myself personally as I'm shooting the jury.
Is this?
But I've been told that I did.
All right. And you were instructed by a bailiff here earlier?
Yes, a few minutes ago.
Okay. So you can't say either way whether you
No,
actually did it or not.
Like I said, if I did it, it was in the middle of moving the shot from one location over to another or something like that. But not,
Okay.
you're not gonna see any shot set on any jurors. That's why
I haven't seen it because the shot was not set.
You're saying you didn't intentionally
No,
violate any?
oh, no, my God, no.
That's all I have from this witness, Judge. I don't know what my office saw other than, I can't put them on, they're not here.
Well,
So if you need to call them, this is your hearing, you go trust it, and I'm sitting here. So
Well,
call them.
they're in Sebring.
We have teams.
the issue with, I know you accommodate us, but the problem.
You've gone over the question, I need to ask this fellow real quick, if he has any questions.
Okay. I have no questions.
Okay. Anything further from the defense?
No, sir.
I'm not going to find, number one, that he's done anything wrong, because I don't think it's been.
And I'm not requesting any sanctions from him, Judge.
I'm also going to find that, number one, the jury has not had access to any of these feeds. I'm not sure that they've gone out live or not. They probably have gone out live. However, I asked the jurors questions, and I told them right before they went to deliberations, they have not seen anything, and they haven't seen anything for essentially 2.5 days. So I find that even if there was an inadvertent pan through that was discussed, it was brought to the court's attention, and the court immediately narrowed it down yesterday and today. At this point in time, I don't think there's any prejudice or taint to the jury, because the jury is sequestered and has not, and is in the jury deliberations. Prior to being sequestered in the jury deliberations, there was none of this information sent to them, received by them, shown to them, and therefore they have no knowledge of it. I am going to order that none of the jury images shall be published, just like in our procedures. So when you edit in your editing situations, please edit that out, blur that out. Obviously, trials like this, there's blurs I do, blurs they do, there's a delay. And we try to do the best we can from a judicial standpoint, from a court standpoint, to accommodate the public. We don't have the room for everybody, and that's why we're using television cameras and cameras here in the courtroom. So I think anything, if it was done, was inadvertent. I don't find it to be prejudicial. I made my ruling, mistrial denied.
Thank you.
Thank you, sir.
All right, state anything further.
No, you're right.
Okay, here's what we're gonna do. We're gonna have a lunch for an hour, Lord. And you say your people will be here at 1, or can they be here at 12:30? I saw somebody come in with a suit, which I assume is one of your people.
I'm looking, I don't recognize.
Is that one of your people or no?
That's true.
Okay. All right, well, it's just another person in a suit down in the courthouse.
Yes.
So,
Well, I've only met one of them.
okay. Is that one you asked him or?
No, he said, no.
Okay, do you have anybody can get here at 12:30? You want to just start at 1? Yeah, and
I
also,
think it'd be safe for one, Judge.
okay, state that you're good with that.
I agree, Your Honor.
And obviously, this is a problem. This is your problem.
Exactly.
I'm not participating. May sit in, may sit out. State may sit in, may sit out. We'll sort it out at 1.
Yes, Your Honor, rather than make this a big disputed, litigated thing, I still think I'm at a disadvantage because some of those experts did some work after I deposed them, but I'm not going to make it an issue. I'm going to let the defense put on what he wants to put on for the record and leave it at that.
And you're going to stand on the arguments you previously made.
Oh, absolutely, Your Honor. As far as I'm not going to relitigate the court's previous order.
Correct. And the court is not relitigating that issue. The court had a hearing and did a rehearing and denied it. However, as you're right, you can proffer whatever you want. The court's going to allow you that entire opportunity.
For purposes of the record, not for purposes of a re-hearing, Judge.
I understand. I get you. So what we'll do is we'll come back at 1.
Yes,
I'll turn the cameras back on. You present whoever you want to the witness stand. I'll have the clerk swear them. I won't be swearing them in, and we'll go from there. All right?
Yes, sir. Thank you.
All rise, please. Until 1.
As far as you know.
Well, how you doing, sir? Good. You get your list?
I just want to let you know. This is one of
Yes, Traction, I'm gonna be in my office.
Oh, thank you. I just keep it there to keep you organized. See how disaster.
Just remember 55.
Oh, he already did. Oh. Oh, don't bring back that. We have to. Sorry to interrupt, Bill. Bill? Here. He already did it, so he can come back a little early once he did it. Sure. Figure out what to do. Yeah, thank you. And like I said, I think I just need to listen back to Bill talk straight out there. It's good.
Jim, catch Jim. Mistakes turn.
Mr. Coleman. Oh. Sorry, no.
Yes, ma'am. Well, it just wasn't supposed to go back.
Right. That's why we had you over there, whether we do it now or do we do it?
And it's probably best to not wait and not, well, we should.
Huh?
They got it.
Yeah, but. Okay.
Fair enough.
Good. You guys cool with pepperoni?
I'm not saying that.
Okay.
No, I mean,
He did.
What you need, huh?
yes, I heard you're.
So any like.
I've never, other than, they never had tables that could face the church. Like, river, that's never practiced it, always like this and facing the judge. Yeah, it's kind of awkward.
Yeah, Orlando's a bit different.
What?
Well, sometimes they, some of the
judges in the corner, and then they have like the council tables almost like diagonal.
Yeah, it's just they have a unit, unit right there. That's.
Yeah.
But no,
Yeah.
Tallahassee. That's crazy.
Oh, yeah.
Just so they can go back.
Yeah.
I know.
Yes.
Yeah, just myself. Okay, we can go to the big leagues.
I replace the batteries when I come back.
Right. Stay at the time. Hey, Ryan, you just stay with me 1 second.
just makes you want to lunch even.
If I wanted to let that door, is it unlocked?
Well, we were going to lock it up because we'd like to take a little lunch as well. No hurry, I can eat in here.
That's fine.
Very accommodating.
All right, thank you. This isn't the one, this is the original.
Oh, well, you're right.
Okay, you're done with it? All right, I'm coming down there and, actually, Billy, you want to take just a real quick trip downstairs? We're gonna be down there, so don't make cuts yet, wait till we get there. I want to make sure Bill's satisfied. Yes, ma'am, this is,
Yeah.
I'll get a,
Bill, did you?
I guess we'll just have to make it.
The same?
Yeah.
Okay. Just make it a B as far as.
Or we can just take the one CD out, put the other side.
Right, yeah, that's what I thought they
Because
would.
it's already marked. I would just.
Oh, yeah,
you know.
that's what I thought he would do.
I got good.
No problem. Yeah.
Lunch for you.
Oh, we got time. Right. We just need to head down to the.
Yeah, one's got to set up their door. They can walk in there before they even eat that bird.
That way you can actually use them.
Well, they can't have, we're not very-
Why don't you guys just sit here for a second, because I gotta fix that evidence. Right, we'll be about that. Thank you so much.
They have to fix a piece of evidence.
Yes.
He said it would be 10 minutes. That means 20. So they're cutting into your lunch. He lost his heat of the state. He did a witness thing. That's what you do.
Oh, you don't really?
You do, or you work there. Not here.
Oh, you're talking about back at Hardy.
Yeah.
Yeah, I'll have my old friend.
Here.
Yeah, while we're giving testimony. Come on. No, he just, I like to set up that desk.
Make sure they actually turn off the stream.
You learned it?
I learned it.
Oh, no way.
Orange light.
Who was in charge of this year?
Well, I don't know.
We're not. So who does, I mean, who was charged with that?
Well, that camera is ATH. That's the primary. Actually, got some food down. Just that. Yeah. Yes. Other. Heat control. But that's the judicial one, not the live. For photos, yeah. I don't know where, maybe that's the camera. For the judicial. So who's able to blur that to me with that tab? Yeah. I just don't want to leave them. And these are the things that he handed me. Because this is one that they took out. Yeah.
Where's that? It's in next in.
Yeah, that's all. Okay, that's all. I checked. I checked. Yeah.
Oh, okay. Get out of that. I will remember if my little ex. Get out of it. No, there's no extra because she, there we go. Okay, first you have to do that. You did the wrong thing, but anyway, go and click on that, because you're gonna need that with the new. I thought that's where you told me to click. No, okay. Oh, okay. Not the note. Oh. Okay. So what am I doing? You're gonna push connect. And now you're gonna enter your password. Which is this one? Yes, don't say it out loud. No, that's what I said. Which is this one. And once that turns green, now you just push that down. Now you should be able to get in clear. Inside here, I need to. Yep. Nope. And you get in clear. Awesome. Trying to do some work. Do you need this bag closer to you? No, I have all my work right here. Okay. Here is, hold on just a minute.
Hey, the judge in here? Do we have an official seating chart? An official one? I need it for the jury now. You don't have like an official? You haven't seen the other?
Dots on there. You know, on the right-hand side, if you look, there's 3 tiny little dots.
No.
It's just to,
Our seating charts look a little different, like the plat, the. Are you in school or something? Yeah, let me.
Lunch. Can you bring it to you?
one that we can use?
Yeah, you did, man. This is one official. This is two official. This is my next one. So what do we need it for?
So, I mean, I don't know if I could use this, the ones that
I
we're
got
using.
another. That's one I made because they didn't have the other one. But I get one. That's right. So taking that.
I need one like this.
I know. I have one like that. I'll tell you what.
Unless I can make a copy of this one.
Yeah, make a copy of that. Let me see it. Let me do that. Yeah, make me a copy. Make a copy of this one. Okay. And make a copy too. One for you and one for me. Okay. I'm gonna wait here for you.
Do you need a scratch or can we?
Yeah, you're all good.
Go
Y'all good? Let's just say. If it occurs. Yes. Oh, that's the wrong thing. Don't darn. Don't want to take this back. Here you go. Here's that thing right here.
Yes,
I know I had it over that. Did you ride with that, the clerks or that girl on that? Keep it, I got one. I have one.
Made extra copies.
Yeah, you're fine. I have one behind. Let's make sure. This is what I have right here. All right. Let's see.
It's in the jury room.
The other jury room.
Okay. I'll see all of that
Judge,
outside.
yeah.
They didn't, I offered, they wanted to, they didn't want to. No, a question. Sergeant Eversaw's gonna call him. Okay. I'm gonna walk out the door. They have to come back and notify everybody. You know,
I'll say that, go ahead, take care.
I'm gonna tell you something. Stand for it, stand by, I'll give you a full time. You're in your office.
Hey, this is Deputy LaCapra up in 9B. Can you have Brad Coleman come up to 9B? The jury has a question. Or 10, yeah, I'm sorry. 10 Coleman, yeah. Okay, thanks.
I can go up. No. Thank you, sir.
you guys got any?
Are you bringing everybody?
No, just me.
I'm not in charge of anybody. I was told to come up.
Jury had a question and they were calling us in. Just the attorneys and me.
Not that I'm aware of.
Okay. It was the one I don't know. It's one that's not from my group.
I'm sorry.
You don't know.
I didn't, I just didn't. Sorry. I apologize. There's cameras everywhere. There's microphones everywhere. And my car didn't get cheated out. So I got a call from the wife and it just called me. Oh, yeah. Hopefully they called us because they had a question. I was like, I was. I'm like, really? So I didn't bother going to get something to eat. Yes, sir. And I'm just going to undertake this. I don't have to pay off the phone. Yes, sir. Oh, no.
Okay, okay.
It's a quick one. I think.
All right.
All right, everyone have a seat.
put it on record.
Let me know when you're ready.
Oh, I'm ready.
Okay, we're on the record in State versus Tracey Nix. We have a juror question. I'm gonna have the bailiff go grab the question, please. Defense counsel's here and State's here, along with clerk. All right, State, come up, read the question. Defense, read the question, and I'll put it in the record. Okay.
Okay. Did you,
Do you want to read it further? I'm going to put it in the record and I'm going to talk to you about it. All right, first juror question is, can we have further explanation as to the definition of gross and flagrant? State, defense, State, what's your position?
Your Honor, I know in these situations whenever they're asking for clarification on the law, often the court decides to advise them that they've received all the laws and the applicable definitions of the terms in those laws, and that apply to this case in the jury instructions. I guess that would really apply to both. I would argue that the difference between aggravated manslaughter and manslaughter is kind of clear. It's either a child or it's not, but again, I can see the court relying upon that standard answer of you've received all applicable laws and instructions in this case.
All right, defense.
Obviously, the jury's confused. That's my concern. I don't think gross is actually defined in the jury instructions or aggravated.
Okay.
Which creates a problem. I don't know. Candidly, I don't want to see a confused jury.
All right, go ahead.
I don't have any definitions of gross or aggravated off the top of my head.
I'm going to tell the jury on that, all applicable law and definitions that apply are in the jury instructions. Okay, we got a second one. I'll say in the jury instructions, please read again. All right, second one. What is the difference between aggravated manslaughter and manslaughter? State.
Your Honor, I think the court has a choice. It can either rely upon, like I said, the earlier statement, or there are elements, and the elements are kind of pretty clear. And according to my memory of those elements, the only difference between aggravated manslaughter and manslaughter is a child. That's what makes it aggravated.
Correct. Defense, what's your position?
I think it's explained in the jury instructions. I don't think we should go further with it.
All right, I'll say the same answer for number 2, okay? All right, let's bring the jury in. Jury's coming in. Thank you. We'll retire you back for.
All rise. You may be seated.
All right, members of the defense and state, make sure the clerk has your cell phone numbers, because if we have one question, we may have more. I'll be in my chambers. We can come back at any time, but I need everybody around. I do know we're gonna start in 15 minutes with the proffer, so if you wanna start early, we can start now.
I'd like to maybe start a few minutes later since we got tied up. I was in the middle of doing that when I got called.
Okay, well, we're gonna start that at 1, okay? All right, thank you. I'll be back at 1, all right?
Create one.
All rise, please. Board is in recess till 1 p.m.
Thank you.
I got you, I'm saying right here.
Hey, Jean. I'm weak. She came back to us, so everybody's straight, let's call. Yeah, that's what it was.
I mean,
Yes.
Issues. My nose is running and my allergy meds ran out. So.
Oh, no.
I don't want to be caught live streaming stuff from my face and my hand. Oh. I was like, I have something.
I know.
Please. It's embarrassing. It's embarrassing not knowing. Hey, you wear pretty tassel shoes, huh? Can't see your feet. Usually when I start, it is
All rise, please.
All right, everyone, have a seat. Let me go on the record of the trial. Just so the cameraman knows, when the jurors are coming in and out, let's not record them at all. Okay?
Well, what happened, Your Honor, was I wasn't in here on the camera.
Okay.
I just got the camera on
No
for,
problem.
and that was unexpected, so when I walked in, they were here, and then I just turned it away.
No problem. All right, just make sure we don't have that anymore. And now we're here, so we're off the official record. However, now Mr. Fletcher's going to do his proffer. So, Mr. Fletcher, the courtroom is yours.
Thank you, Honor. I call Dr. Bethany.
You do record this, but it's not, I'm just, it's here. Right here.
Please make your right hand. Do you solemnly swear or affirm to defend the whole truth and nothing but the truth, so help you God?
You just have to switch.
The state's not going to be cross-examining, they're not, this is a new trial, I just want to make sure that's clear on the record.
The record's clear. You and I are just both sitting here. I'm doing some other work and you're doing whatever you're doing.
Thank you.
Go ahead.
Thank you, Your Honor. State your name, please.
Dr. Daniel E. Buffington, Buffington.
Okay. Have you ever testified in court?
Yes, sir.
Okay, approximately how many times?
Oh, since the early 90s, probably now in excess of 500.
Okay. And what's your specialty?
Clinical pharmacology and toxicology.
Okay. Have you ever been, I assume you've been qualified in court in those fields of expertise more than 500 times?
Yes, sir.
Okay. Can you give us your education, training, and background?
Yes, sir. I did my undergraduate studies in biology and biochemistry at the University of South Florida, a native of the Tampa Bay area. Following that, I did a Doctor of Pharmacy degree, or PharmD, at Mercer University in Atlanta. After that, did postgraduate specialization at Emory University in residency and fellowship in clinical pharmacology and tox. And then after that, also completed an MBA with a healthcare focus from Mercer.
And have you reviewed the case records and interviewed Tracey Nix?
Yes, sir, I did.
In this case? Okay. Do you have any particular methods that you'd like to tell us about as far as what you did and what you used?
Yes, sir. So similar to a clinical evaluation with a patient in any inpatient or outpatient setting, my goal was to go through a variety of records that would be beneficial to understand her history, medical, medication, family and social history, laboratory results and data, any prior hospital and clinic records that would help to identify and support an understanding of what medications she was on, pharmacy records, helping to confirm exactly what substances in terms of medication she was taking around this time.
Okay. And can you tell us what all you reviewed?
So I reviewed hospital and clinic records. I reviewed law enforcement records from this particular case. It also included a clinical interview with Ms. Nix as well to have a better understanding of what was happening in her life and any symptoms that may have been consistent with the adverse side effects of the medications that she was being prescribed.
Okay. Anything else that you reviewed in this case?
Yes. So in addition to my training and understanding, it's imperative to stay current in the medical literature. So I did look at medical literature surrounding these particular medications. That can come from a variety of clinical trial data. It can come from FDA approved materials that a manufacturer is required to organize and make public to healthcare practitioners to understand the therapeutic benefits, but also the adverse side effect profiles and risk for medications. There's a variety of other databases that we use in clinical practice. We call them pharmacovigilance, and that is where we, not only when a product gets approved by the FDA, does the manufacturer have to disclose for a specialty panel to understand, to approve that product for use in the United States. That type of tracking goes on for years. So we have MedWatch, we have the FARS database, we have multiple established database systems that healthcare practitioners contribute to even after a product is approved and in the market. And in many cases, we find more out after a product is out in use in large number of patients than we did even at the time a product was approved. So there's also a series of drug interaction databases where if I'm sitting down in a clinic or if I'm doing a forensic review, I can put the patient's medication profile into that data set and then identify if there are in fact drug-drug interactions, meaning one drug competes with another, one drug causes a complication in another. And to a great extent, what we know now is all of us in this room may metabolize the same drug differently. That could be that you don't get as much effect versus the other person. It could be that you get a dramatically higher effect than the other person. So I went through each of those tools that I use in my own clinical practice setting to review this case.
Okay. Anything else other than what you indicated that you reviewed?
I think that's comprehensive. Yes, sir.
Comprehensive?
Yes.
Okay. And did you review case-related depositions?
Yes, sir.
And you already indicated police reports?
Yes, sir.
And some transcripts?
Correct.
And text messages?
Yes, sir.
And photographs?
Yes, sir.
Okay. Did you render a specialty opinion within your education, training, and experience as to the origin and cause of any issues that Tracey Nix may have had with regard to any altered cognitive status at the time of this event on November 1st, 2022?
Yes, sir, I did.
And could you tell us, please, what your findings were?
Yes, sir. The findings are that the collective list of medications that I confirmed by medical and pharmacy records gave me a clear indication of what she was being prescribed simultaneously during that time.
Okay.
The symptoms that she was experiencing, as based on the interview and based on her statements, are consistent with the adverse side effects with regards to cognitive status, confusion, attention deficits that come with those medications. And in fact, there were multiple combined reasons for concern or interactions between the medications she was prescribed.
Okay. Did you identify any significant variables in her past medical history that factored into your findings?
Yes, sir.
And could you tell us about that?
So specifically when looking at her case is in patients 60 and 65 and older, we use significant caution when introducing or prescribing certain medications. In fact, we even maintain a national list or registry of those products called the Beers list. That's named after Dr. Beers. And in that, she was on multiple medications that would be of high concern or risk factor for these types of side effects that are recognized in the Beers list, as well as in the FDA-approved packaged materials and the other patient safety databases as well.
And these were actually the medications you're talking about were all prescribed to her?
That is correct.
And you know who did the prescribing?
I have it in my notes, but I didn't take the practitioner's name to memory.
Okay. Did you identify any significant variables in her past social, family, and work history that factored in your findings?
Yes, sir.
And could you tell us about that?
So in addition to her age and history of insomnia and depression, fibromyalgia and sleep apnea, things that she was being treated for, I also identified that she had a family member, a brother, a sibling, who was also experiencing, going through symptoms of early onset dementia, which would have been concerned. She expressed concern that she may attribute some of what she was feeling or experiencing with confusion or mental clouding as being something familial that was happening. There was also work-related examples. She was previously in a leadership position in a school, had transitioned from that based on age and duration of work time, was working for another school. In that situation during this time, she expressed that she, as well as her supervisor, were noticing difficulty for her to identify and retain attention and completion of tasks, again, consistent with the types of symptoms that these medications, when used, can cause.
Did you identify any significant variables in her past sleep-related disorder history that factored into your findings?
Yes, sir. Combination of insomnia and sleep apnea, both are disruptive disorders to getting what we call restorative sleep. That impacts someone during your sleep. In fact, some of the medications she's on actually are prescribed or used to help with sleep, but they can cause what we call complex sleep-related disorders or behaviors. And that's where the risk is in a percentage of patients, you're giving it to help them sleep, but it may actually cause abnormal behaviors, thought processes, or disrupted sleep. And that can be something that occurs during the night or during a period that the individual is sleeping, whether it's night or day. Or it can also be what we refer to as next day cognitive decline or next day drowsiness, where the individual isn't as sharp. And it's not just that they aren't trying to get enough sleep. It's not just that they aren't taking care of themselves. It's something that these particular medications induce on a person and actually worsen the quality of sleep and cause mental clouding and confusion the next day, even after they've been up.
And what drugs are we talking about?
So those in particular are Ambien and cyclobenzaprine and also lorazepam. So there's each of those represent a different class of medications, but each of those carry with them significant concerns and warnings over the ability to produce these types of changes in cognitive status, clarity, attention, and thought process.
Are any of these medications on the Beers list?
Yes, sir. Each of those.
All of them are?
I would have to double check for the cyclo, but I'm pretty sure it is as well. But the benzodiazepines and the zolpidem, that's the generic name for Ambien, is clearly on that list. It's so much on the list that the FDA requires the manufacturers to disclose, makes it a substantial warning, and has even in recent years said it has to be disclosed to patients when they're doing direct-to-consumer advertising. So that means that it's not just something that only a few people should be warned of. It's something that everyone should be warned of.
Let's look at Ambien. As a pharmacologist and a toxicologist, would you recommend that Ambien be given to a patient 65 years of age on a long-term basis?
Absolutely not. It would be for short-term use in an acute emotional scenario where the insomnia has occurred abruptly. It is not going to be safe to use long-term. And in fact, there are alternatives that would make it not even desirable in my practice setting to recommend it to someone 65 and older. In fact, the incidence that I see those types of side effects and problems is high even in patients under 65. It's not a product that I recommend.
Okay. And what about, I'm going to use a trade name, Flexeril?
Yes, Flexeril is a muscle relaxer. So Ambien or zolpidem was a medication used to help induce and keep you to get a sound, restful sleep when it's doing its job right. Flexeril is something that actually relaxes a person if they're having muscle spasms, if they're having fibromyalgia. That's the times it's reached for as a therapeutic tool. Many patients have to discontinue that product because they have cognitive status changes. They have balance changes, normally able to traverse, walk safely. Next thing you know, we're identifying they're stumbling, they're falling, they're feeling dizzy, confused. So it's a medication that, again, it's been around a long time, but it's got limited use and should not be used in patients 60 and older.
Lorazepam.
Lorazepam's yet another therapeutic class. It's in the benzodiazepines, so like Valium and Xanax and others. It is a medication that has many uses, but many of them are because of its side effects. So it is a muscle relaxant and something that can sedate someone. So in that case, some prescribers may suggest it for sleep. The problem is it can also cause extended next day drowsiness. So it's not optimal. It's not optimal in an older patient. It's also something that can cause hallucinations, anxiety, even though it's something that can treat anxiety. So it's a medication with many different effects on the human body and the brain, but would not be recommended for someone who's having confusion or attention issues.
Okay. What about a person 65 years of age or older?
No, sir, it would not be recommended, and certainly not for long-term use as a sleep aid.
Okay. What about the combination of these medications? Would that be appropriate to prescribe that on behalf of a patient, all three of these in combination with each other?
No, sir. Given the circumstance of her unique patient profile, of her as a person, as an age, as medical conditions, it would not be recommended. So this was not an optimal drug regimen profile for her. The other issue is that it would not be recommended based on the fact that each of these can cause lingering, enhanced complications that are not helpful for the patient.
With respect to the Zolpidem, also known as Ambien, did you determine that she was on an appropriate dosage of that?
Given her age and size, that is actually a large dose. So again, if you dive deeper into the analysis of her medication regimen, it wasn't even like a starting dose. It wasn't an introductory dose. It was actually a substantially large dose, and that would not be recommended. In addition, I looked at the combination of medications and for drug interactions, and there were numerous drug interactions between the medications she was on.
Do you consider it to be malpractice for a practitioner to prescribe these three medications, including Zolpidem, in the amount that it was prescribed?
In this particular case, I would express significant concerns combined with the fact that was there a monitoring program in place to identify those? And in the review of the records, I didn't see that. These look like medications that have been put on, doses increased, and then left in place. And I saw that throughout 21 and 2022.
Okay. Other than what you testified to, do you identify or have you identified any significant variables in her past memory and recall history that factored into your findings?
Well, her own testimony of what had been changing at a workplace setting, she also identified that there were times when driving on daily tasks that she had gotten lost in areas that she was previously familiar with. So whether or not this was an element of an onset or development of dementia type symptoms, or whether it was dementia related activities as a result of the medications, both of those would be a concern in her medical history.
Other than what you've already testified to, did you identify any significant variables in her past medical and hospital records that factored into your findings?
Just as I stated before, the presence of insomnia and sleep apnea would be even greater reasons for a prescriber to avoid these medications. Then there was the age, and then was looking at them in their totality, all of them together, and saying this is an okay regimen to stay on, was really overlooking the risk that was being induced.
And obviously you review the medical literature. Can you be specific?
Yes, sir. So first and foremost would be the FDA approved package insert on these medications. They specifically warn of these concerns. The Beers list is a industry-wide tracking tool. It specifically gives concerns and warns in her situation. And then in addition, the pharmacovigilance databases, the MedWatch, the FARS, also highlight those, and those are available to any healthcare practitioner to use as a clinical reference. All of these things demonstrate a consensus that individually, these medications and combined would be disadvantageous in her situation. And the symptoms that she expressed as concerns are directly consistent with those symptoms we would see.
Okay. Did you find support or consensus in the published research and medical literature to support your clinical findings and opinion?
Yes, sir, an abundance.
Okay. Can you be specific?
Yes, sir. The MedWatch, the package insert, the FARS data set, publications that are specific to individual medications and their drug interactions as classes. I have large sets of files for tracking and teaching these very points as well.
Can you tell us the opinions you reached after your review in this case?
Yes, sir. The opinion is that her collective medication profile at that time placed her at risk, and the adverse side effects that she was experiencing, noting, they even appeared in her medical record, is that after the lorazepam was added early in 2022, this occurred in November of 2022, that there was a development of symptoms consistent with and do appear to be have been caused by her collective adverse side effects from her drug regimen.
Okay. Make any other opinions in this case, sir?
I think that's it.
All right, I'm gonna. It's hard not to be formal and ask to appraise the witness, but I guess I don't need to do that.
It's your courtroom, I'm just.
It's my court.
I may get up and
Yes, sir.
come back, you never know.
All right,
Your courtroom.
Thank you. Can you tell us what that is?
Yes, sir. So this would have been part of those methods. So when I sit down with a patient in an exam room, in a hospital room, in a clinic, anywhere, this exercise is the same. I start off by looking at what their baseline conditions are that need treated. Then looking at what has been previously prescribed as therapy versus what's currently medication profile. Most of that is, the objective is to discern, are they on the right medications to treat their conditions? One of the next steps as a specialist is to actually go a layer deeper and say, are the medications that the individual is on, looking at them individually, but then looking at them collectively, have the potential to create problems? The number one healthcare tool and treatment modality in the United States is medications. More than surgeries, more than anything else. The number one healthcare related harm, meaning you go for treatment and you have complications, is adverse drug events. So the two of those go hand in hand. This table that I prepared demonstrates on the left column the list of medications that she was on collectively.
Okay.
Across the top are adverse side effects that are consistent with neurologic status, cognitive status, behavioral changes that take place. So these are neurologic complications. In the boxes across the table, anywhere there's a red X, that drug carries with it the risk of producing that side effect.
Okay.
So I refer to this as, once we've looked at, are you on the right drugs? I'm now looking at, are there problems by combining, prescribing any one of them or combining that may be contributing to your baseline symptoms or now new symptoms. So in this case, we call this the side effect burden, meaning not one, but multiples of these medications are all causing extremely similar adverse side effects. So it's synergistic, meaning just like we want to say we're treating the core issue while you got the prescription, we're also now collectively creating a more dangerous scenario for the patient.
Okay. Is there a way you can go through and tell us the drug she was on and the reactions as per that table?
Yes, sir. So the first drug and greatest concern is Zolpidem or Ambien. And in fact, it's the sustained release, and she was on extremely large dose, bigger than a dose that I would anticipate taking. So you can have CNS depression or mental symptom depression. You can have complex sleep-related behaviors. That's where an individual goes into a REM cycle and it's not normal. And actually sleep walking, sleep talking, sleep driving, sleep doing other things that they're not cognitively in command of. So abnormal thoughts and behaviors, physical behaviors at the same time. They could have cognitive dysfunction or confusion, disorientation, amnesia, hallucinations, delirium, depression, drowsiness, a whole host. Then if you go to the next drug, cyclobenzaprine, very different product. This one's used for muscle relaxing. And in fact, it carries with it most of those same adverse side effects as a potential complication. Even her meloxicam, we didn't mention that earlier. The brand name of that is Mobic. That would be like an advanced version, more potent version of an ibuprofen or a naproxen. And you say, well, clearly that's an anti-inflammatory. That would not have any central nervous system adverse side effects. I'll challenge you to look at the literature. It has adverse side effects because of the changes in cells and receptors in the brain at the same time. It has a different function, but it carries with it side effects, not as many. Cymbalta or duloxetine was her antidepressant. It has many of these same. And then adding the Ativan is probably worse than the ones above individually. But now it's created a compound effect for mental status change and cognitive decline.
Okay. All right. Any other opinions that you formed in this case that we haven't talked about?
I think that's it.
Okay. Thanks, sir.
Thank you. I'm done.
Since it's my court, you're excused.
Thank you.
Your Honor, just for clarity of the record, if the public comes around and looks at this, I do want to make sure it's clear that the deposition the state took of Dr. Buffington October 30th of 2024 is attached to the motion that the state filed to exclude these witnesses November 26th of 2024.
That was my recollection, it was approximately 90 pages, 3 different depositions were attached.
Yes.
7-page motion, 83 pages of other.
Correct, Your Honor. I just want to make sure that's also on the record since we're just, I guess, putting stuff on the record here.
That's fine, you guys can do that. I mean, go back to my chambers or another matter. Sure.
Going to call Brian Escobedo, Your Honor.
Do you swear or affirm that you will speak the truth, the whole truth, and nothing but the truth, so help you God?
I promise. One thing I do want to put on the record for Mr. Escobedo, he was a person that was participating in jury selection. It's the same right next to us, correct?
Absolutely. Yes, sir. Yes, sir.
All right, go ahead.
Subsequent to your ruling precluding him from being a witness, we did do that. Yes, sir. Would you state your name, please?
Ryan Estevez.
Okay, and how are you employed, sir?
I'm self-employed.
Okay, and what do you do for a living?
I am a general and adult and geriatric psychiatrist.
Okay, and how long have you been in that particular profession?
This will be my 23rd year.
Okay, can you tell us, please, your education, training, and experience in the field of forensic psychiatry and other fields of psychiatry?
Sure. I initially got my bachelor's degree in psychology at Stanford University. Following that, I got a master's degree in social psychology, also at Stanford University. From there, I did my MD and a combined PhD in experimental health psychology and neuropsychopharmacology at Tufts University. Following that, I did an internship at University of Texas Southwestern Medical School in Dallas in medicine, psychiatry, and neurology. Followed that, I did my residency in adult psychiatry at the same place, University of Texas Southwestern. Following that, I did a master's in public health at Harvard University in Boston. And following that, I did a research fellowship at Harvard and UT Southwestern. Following that, I did a geriatric fellowship at UCLA Semel Institute for Neuroscience. And finally, I did a fellowship in forensic psychiatry at University of Florida, McKnight Brain Institute.
Okay. And are you licensed to practice medicine in the state of Florida?
Yes, I am, as well as the state of California.
Okay. And are you board certified in any certain areas of medicine?
Yes, I have 6 board certifications. The first is in general adult psychiatry, and I also have a subspecialty board certifications in consultation liaison psychiatry, geriatric psychiatry, forensic psychiatry, psychosomatic medicine, and addiction medicine.
Okay. And have you ever testified as an expert?
Yes, I have.
Okay. In the state of Florida?
That's correct.
Have any idea how many times?
I don't keep a notebook of how many times. I don't know, 100 times perhaps.
How many?
Tens, perhaps 100 times. It's
100 times.
It's in the tens.
Okay. You've also testified as an expert in other states?
That's correct, in
Okay.
California and Texas.
Okay. And you would testify in the areas of psychiatry?
Psychiatry, psychopharmacology, and geriatric psychiatry or memory disorders.
Okay. And did I ask you to evaluate Ms. Nix in this case?
Correct.
Okay. Can you tell us specifically what you did in order to evaluate her?
Sure. The process is the same as I do for everybody that I examine, in that if I agree to do an initial review of the case, I ask for all the medical records, any mental health records, and any other records that might be important, let's say jail records or anything like that, if they have a criminal history. And then I interview the individual, which I did with Ms. Nix. Interviewed her for several hours and did some preliminary neuropsychological testing. Following that, kind of review the record again, consult any literature that I might need to consult that might be helpful, and then form an opinion.
Okay. And can you tell us specifically your opinions that you formed in this case?
Sure. So, as I try to be as unbiased as I possibly can, but I must admit, there's an initial sort of visceral reaction to something like this case that happens. But you go and you try to figure out what's going on here. But I initially thought, okay, kind of like I look at it like a puzzle, which often is a puzzle. What's going on here? What has not been said, or what is there anything that hasn't been looked at or not? Sometimes it's very straightforward. Sometimes it's not. So I was surprised when I evaluated Ms. Nix that I didn't realize at that time until afterwards that I kind of perhaps expected somebody different than what I actually evaluated. And when you think of a case like this, you think, oh, what's going on here? Is this person, scattered brain? She on drugs? She careless? And you would expect to see those things in other aspects of her life too. And what I found was, a retired school teacher who had devoted her entire life, 40 some odd years, to caring and educating children. And she's, absolutely no drug history, very kind, very articulate. She was easy to interview in the sense that I didn't have to constantly kind of.
I do want to say, I thought we were proffering expert testimony, not character evidence.
What?
I'm gonna say it's his proffer. I'm gonna actually step out for now. Y'all just keep going. When you get something that you need me, let's just contact me, okay?
Yes, sir.
All right.
Okay, Jim. Thank you.
What you were just testifying about before the objection from the prosecutor, did this form part of the basis of your opinion?
But absolutely, it has to. Absolutely. I mean, I'm noting every sort of aspect of her personality and characteristics about her, presently as I'm seeing and historically. So these are important things in order to form an opinion. So
Can you continue?
yeah, so I was while interviewing her, thinking something's off here. This is not this doesn't sort of reconcile with the event that happened and this person historically. They don't add up. They don't match up. And but you know, I didn't know what it was. So you know, once I really started digging into the medical records, was, you know, not particularly remarkable. I did note that she had was diagnosed with a fibromyalgia about 20 years ago, taking some medicine for that. And then I reviewed her medications and her medication history, and I found something that I thought was noteworthy, in that she had been prescribed various medications, but had been taking 3 ones that I thought were noteworthy from a psychopharmacology perspective. And that is, she was taking lorazepam. Now, this is a potentially habit-forming medication that is given for anxiety, but only intended to be given for a maximum of 4 months at a time. It also has safety warnings regarding dosage for the elderly. In addition to that, she was also given a drug called Ambien controlled release. And she was, this is another one that has a safety warning. Actually, was issued after the drug came out in 2013 that said recommended or warned against doing any activity that required mental alertness, including driving the day following taking an Ambien CR. Not only was she given that medication, in early 2022, her PA that was seeing her, she was not getting these prescribed by a medical doctor, it was a PA, doubled the dose to a dose that was twice what was recommended for elderly individuals.
So that's twice
Twice the
dosage?
Yes. And
recommended or
right
for an elderly person?
Right. It's also noteworthy to know to mention that Ambien CR, one of the characteristics of that neuropsychopharmacologically, and you know, I won't bore you with the mundane details, but women metabolize it about twice as slow, let's say, as the rate of men. So it's particularly important to mind dosages for women. Finally, that wasn't the only thing. It was also, she was also being prescribed something called a cyclobenzaprine. She was being prescribed this for her fibromyalgia, but this is a muscle relaxant, and also has something called anticholinergic properties. These are a side effect of the medication that affects the brain specifically and can cause confusion, sedation, weight gain. And this is another medication that is recommended to actually not be given at all to the elderly because of these anticholinergic properties. And she was being given prescribed that medication as well. So there was,
said, let me interrupt you. You said recommended not to be given at all to elderly persons.
That's correct.
I presume 65 years of age.
That's correct.
Would be that. And you said recommended by what entity?
Sure. Excuse me for not mentioning that. The American Geriatric Society publishes every few years. The last one they published was in 2023. A list of medications that are called the Beers medications, BEERS. And these are a list of medications that are recommended. The recommendation comes in strong, moderate, weak, and to avoid, use with caution, or, you know, okay to use. And these are all medications that are specifically targeted, or they're talking about in relation to the elderly. It's the American Geriatric Society that publishes it.
Yes, sir.
And for actually all three of them have a void recommendation, and all three of them have a strong of the recommendation strength. They're all three strong. So she's on 3 medications. Now, this doesn't mean you absolutely can't give it no matter what. You're not going to jail if you're going to give it. But if you are, as a responsible physician, Certainly, if you want to avoid some sort of malpractice, you better have a good reason why you're giving that medication to an elderly individual. It should be documented, it should be, put down and explained to people that, like me, that might be reviewing, like, why are you doing this? This is potentially dangerous. And so there was nothing like that, anywhere in the chart. It was just kind of casually given. Furthermore, cyclobenzaprine is not even a medication that is approved or even used off-label for fibromyalgia. It just doesn't work. It's not a helpful medication for that condition. But nonetheless, she was prescribed that. She's very conscientious. She does what her healthcare provider tells her. Told her what to do when to take it, and that's what she did.
Is that appropriate to follow the recommendation of your healthcare provider?
Absolutely.
You're allowed to do that and not question it.
I think it's probably better that you do that and not question it.
Okay. Cool.
I mean, you should always, share your information with other providers. If there's something going on, you need to share that too with your healthcare provider. If you're throwing up or you're having problems related to that, you need to let them know. Which she did, mind you. I don't know if we might be backtracking a little bit, but she did. She was up front and forward with her physician. But nonetheless, she was prescribed these medications and was taking them.
Okay. What else did you do in this case, and what other findings have you made?
So, predominantly, the psychopharmacology is predominantly the findings that I made and how I feel that affected her behavior and her alertness and her cognition. And that was kind of consistent throughout. That kind of fit her whole picture rather well, and kind of gave an explanation that otherwise was missing, in my opinion.
Do you have an opinion as to a reasonable medical certainty how this medication affected her?
I do. Yes, I do. I believe that it affected her alertness, her mental acuity, and her concentration to a significant degree and for a prolonged period of time.
This is based on medical reports you got from her.
My interview with her, my review of the records, all of the records, and my experience. Yes.
When you say records, be specific.
Medical, which also, psychiatric, which includes psychosocial, and pharmacological. So, review of the records, interview, neuropsych testing that I did, and my experience over 20 years of doing this.
Any other opinions or findings that you'd like to share with us?
Well, I do. So, one thing that that kind of bolstered my opinion was that there were things that were going on that kind of let me know that there was something untoward or something that was off about her. She retired from teaching. I think it was around 2021. Now, prior to that, she had been hired by the schools and outside of the regular public school system to work at a new school that was opening, and was there, I believe, for a year. And I came across a letter that was written by, I believe, the owner and principal of the school, explaining why they weren't firing her, but that they weren't going to have her come back the following fall, right? And it's a very well written letter, and it just delineates all of these things that were going on with her, giving the wrong assignment to kids, calculating incorrectly, stapling bundles of things that they take home incorrectly, like lots of little kind of concentration or basic errors that were going on. And this is in contrast to the person that I had seen and that I had tested that was just so sharp, so on point, had her details there. And what was the difference really between pre and post? What was the difference between the person I was seeing and the person that was being described in detail in that letter? And the only thing that was different is that she was no longer taking the medications and hadn't been for probably maybe 11 months by that time, had not been taking these medications, had them completely cleared out of her system, versus when she was taking these medications. And you would expect that, those are symptoms that if you have a neurodegenerative disorder like dementia, Alzheimer's disease, that sort of thing, that's something that at best will progress at a very slow rate. But it's a progressive neurodegenerative disease. You expect it would be at least those same symptoms or worse, right, at the time I saw her than they were when it was being described here in this letter in very minute, specific detail. She was better. She didn't have any of those things. What can account for that? Well, we know very well. I mean, this isn't speculative. We know that these medications can cause difficulties with cognition, concentration, mental acuity, alertness, awakeness, all of these things, and that's in everybody, but exacerbated in the elderly. And again, this is not, I'm not coming up with this. This is something that is very well accepted and not a controversial sort of finding. The Beers criteria, the American Geriatric Society, with all the best geriatricians in the world and psychopharmacologists come together every few years and update and recheck and look at this list. And they're the ones that have build the consensus for that. And if it's controversial or, they doesn't make the list. And so, I think that it's important to emphasize that.
Did you talk to anyone else besides Ms. Nix about these matters?
I did. So I spoke to that principal that wrote that letter. I was just surprised to see a letter in such detail and specific, but I still wanted to get, her own. I wanted to hear it from her about these things that she had in the letter. And I spoke to her. I spoke with Mrs. Nix' husband. I've spoken with her daughter. And I believe that's it.
Okay. And when you indicated you interviewed Tracey Nix, that was obviously months after this event occurred on November 1st of 22, and you found her to be basically normal?
Yes, and that was the end of September of 23 is when I interviewed her initially.
And do you know when she quit taking these medications?
I do. It was when she got off. All of them finally were by April of 2023.
Okay. Anything else you'd like to tell us about this case and your findings in this case, or observations or your opinions?
I don't believe so, not at this time.
Thank you. You're excused.
Okay, thank you.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
State your name for the court, please.
David Diamond.
And how are you employed, sir?
At the University of South Florida, I'm a professor in the Department of Psychology.
Okay, and how long have you been so employed?
Almost 30 years.
Okay. And could you tell us your education, training, and experience in the field of psychology or what other specialties that you may have?
I received an undergraduate degree in biology from the University of California, Irvine, and a PhD also in biology with a specialty in neurobiology of memory, also from University of California, Irvine at the Center for the Neurobiology of Learning and Memory. I had a postdoc at the Department of Pharmacology at the University of Colorado Health Sciences Center. And ever since then, I've been a professor in psychology at the University of South Florida.
Okay. All right. And what is your specialty, if any, sir?
My primary specialty is the study of the brain and memory.
Okay.
May I add that I've also been a career scientist at the Veterans Affairs Department for 30 years, with my specialty being post-traumatic stress disorder, which is fundamentally a memory disorder.
Okay. Can you give us a summary of your contributions to science?
So I have primarily studied all different aspects of the brain and memory. I've studied how people are affected by trauma and develop post-traumatic stress disorder. I've studied how the mechanisms of memory are affected in both animals and people. I've published work on memory in animals and clinical studies on people. And so more recently, I've been studying the phenomenon the last couple of decades on how children are forgotten in cars.
And have you ever testified in court regarding memory issues and or children left in cars issues?
Yes, I've testified numerous times in different states, in criminal trials, civil trials as well, as a result of children being forgotten in cars.
Okay, can you tell us how many different states you've testified in with regard to that?
As I recall, 5 or 6 different states in which I've testified specifically in criminal trials.
Okay. And also other countries?
Yes, I've also testified on a case in 2 cases in Australia. One involving a child that was forgotten by a mother in Australia.
Okay. And how long have you been studying about, we'll say, the issue of memory and how it may affect children being left in cars?
So I do remember very well when I began studying this. It was about 20 years ago when I'd already been studying memory for decades. And I received a call from someone, a news reporter, asking me as a memory expert to explain how it is that so many hundreds of children have died as a result of being forgotten in cars. And I will admit at the time, the fact that I understood all about memory, and in fact, I studied forgetting. I had no idea what the reporter was referring to. But as a scientist and also as a parent, I was very curious. So I then started doing research on my own. And I found websites, kidsincars.org and noheatstroke.org, where they had been keeping track of children that had been forgotten in cars. And I learned that hundreds, this is 20 years ago, at the time, hundreds of children had died as a result of being left and forgotten in cars. They had died of heat stroke. That's therefore how I began my study, was to appreciate the numbers, which were staggering. I learned that the children that now are being forgotten in cars, it was largely unheard of. It hadn't happened prior to the development of airbags. So before there were airbags in cars in the 1990s, children in general were put in the front seat. And so you're not forgetting a child that's immediately next to you. Once children were put in the back seat, in particular facing the rear, when you have infants in the back seat, then you start seeing people forgetting kids in cars. So there's first an obvious pattern that we see, which is children are forgotten in cars beginning in the late 1990s. And what we have now is an epidemic Last year, 39 children were forgotten and died in hot cars.
How many?
39 children were forgotten that died in hot cars. So we've had hundreds of
Could you hang
children.
on just a minute? I apologize, Dr. Diamond. I misheard something.
So what I do as a part of my research is to monitor the number of children. And the way I do this also is that I'm on task forces that keep track of children that are forgotten and die in cars. I'm on a task force in Florida because of the heat we have in Florida. We have a very high percentage of children that die in hot cars. I'm also on a task force in Texas where they have children, a very high percentage, but actually almost every state in the country, children have died in hot cars. I'm also on an international task force funded by the United Nations because children have died in hot cars all around the world. So we're looking to combat this epidemic of children dying in hot cars.
Have you been published?
So I have an online article in which I have described the neurobiology of what is going on when children are forgotten in cars. And this is a result of the way I do the research. So I personally interview dozens of parents, caretakers, and grandparents that have forgotten children in cars. I read the literature, I read the media reports as to what is going on, as to what is happening when a person is forgotten, when a child is forgotten in cars. So initially, I wrote an online article to explain this, which is an academic online journal called The Conversation. And that article has had over 150,000 views. I then evaluated the literature, the neuroscience.
Okay, everyone have a seat. You keep going, but we have a verdict, your choice. You all can have a seat.
If I can do this after the verdict,
That's entirely up to you, yes.
As I was saying, as a neuroscientist, one who has studied memory all my career, I then evaluated the neurobiology of children being forgotten in cars. And so I published a paper in a hybrid medical legal journal with the help of a law professor, Medicine, Science, and the Law. This is a peer-reviewed medical journal in which I described the medical basis of how it is that people can forget children in cars. And this specifically, I want to emphasize, this is for people who are not on medication. I understand that in this case, we have an issue about medication affecting Tracey Nix's memory, and that's certainly valid. But independent of medication, we have hundreds of people who have forgotten children in cars, and that is independent of medication impairing their memory. And this was a part of my publication in Medicine, Science, and the Law.
Okay. You indicated you've written some publications. Can you tell us, or do you recall what states you've been a witness in with respect to the issue of children in cars, being left in cars?
Off the top of my head, I've testified as an expert in Texas, Wyoming, Arkansas, and a couple of other states.
Virginia?
And Virginia.
Okay. Have you also consulted with prosecutors regarding this issue?
Yes, I've not only been contacted by defense attorneys, I've been contacted by prosecutors. One in particular, this happened numerous times, so one in particular was a prosecutor in Utah in which a mother forgot a child in the car and the child died. That prosecutor contacted me, telling me that he was considering charging her with a crime, with manslaughter, but he wanted my opinion as to how to go about this. Did I actually consider, well, in his opinion, is this a crime? And we spoke for a good long time. We spoke for about an hour, and I explained to him the neurobiology of this phenomenon. I explained to him and shared all the research that had shown how many hundreds of children had died to really good, attentive, and loving parents, that this is not happening to reckless people. And at the end of our conversation, he decided not to charge her with a crime. And what I was really pleased with was he actually put out a press release, which included his discussion with me as an explanation for why he was not charging her with a crime.
All right, let me go ahead now. We're gonna break this. I'm gonna
Yes,
put the verdict in. I
Yes,
just got my laptop, which I needed to have the verdict come in with. State,
No, Your Honor, I was just about to say, I didn't know if I heard the court correctly, so we have a verdict. So
we do have a verdict, and so you need to step down once we're done with the trial. Whichever way it goes, you can have the courtroom and the court reporter. So sir, please step down. All right, Judge Willis, you ready for your verdict? All right. Awesome. All right, everyone understand the verdict's coming in. We don't have a lot of trials on Wednesdays, so we just have some bailiffs that are gonna step in, some other lawyers are gonna step in just to see the verdict come in. Understand?
Yes, sir.
Thank you. All right. Is Poulos out there?
Yes.
Okay, don't bring him in. Okay.
Ready, Judge?
All right, yes.
All rise.
All right, everyone have a seat. We're back on the record for State of Florida versus Tracey Nix, CF 22-289. Members of the jury, did y'all reach a verdict? Who's if my foreperson would raise their hand and hand the verdict to the bailiff. All right, defense, please rise. Mrs. Nix, please rise. All right, we're going to go ahead and publish the verdict.
In the Circuit Court of the 10th Judicial Circuit of Florida in and for Hardy County, State of Florida versus Tracey Howard Nix, case number CF 22-000-A000-XXW. Verdict form. We, the jury, find as follows as to count one of the charge. The defendant, Tracey Howard Nix, is not guilty. We, the jury, find as follows as to count two of the charge. The defendant, Tracey Howard Nix, is guilty of leaving a child in a motor vehicle in excess of 15 minutes, causing great bodily harm.
Don't read, just don't read anymore.
Yes, sir.
All right, thank you. Mr. Fletcher, do you wish the jury to be polled?
No, Your Honor.
State, do you wish the jury to be polled?
No, Your Honor.
I'm going to release the jury.
No objection.
All right, all rise. Members of the jury, I want to give you your final instruction. Hold on one second. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors such as yourself. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, and elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. I want to thank you on behalf of the citizens of Hardee County and Polk County for spending your time with us. Thank you very much for your time and consideration. You may be excused.
Even though.
All right, all, once they leave, have a seat, and I'll have them to defend it, proceed to the podium with their attorney. Okay. Once here. Right there. Okay, Ms. Nix, stand next to your attorney, Mr. Fletcher. Everyone can have a seat. Mr. Fletcher, Tracey Nix, having been found guilty by a jury as to the charge of leaving the child unattended in the vehicle for more than 15 minutes, contained in case number CF 22289, I now find you to be guilty of the offense. State what's your position on remand or bond.
Your Honor, she's been convicted at this point. I would ask that she be taken into custody.
Defense position on remand or bond.
Your Honor, I request that she be allowed to be out on bond until we have a sentencing hearing. Will be requesting a less than guideline sentence. I will request, based on my experts, that you partially heard that her sentence be below guidelines. I have also had my office contact bail bondsman. He is willing to remain on the bond. I can tell you that as an officer of the court. There's plenty of time to incarcerate her. I do need her also to be able to prepare for sentencing.
All right, state anything further?
And further, Judge, she's been on pretrial release for over 2 years. There hadn't been a seconds problem with her. She's been to every court appearance that we've had, and I see no reason to remand her at this time.
State anything further?
No, the state stands by its previous position.
All right, a sentencing date of April 3rd at 8:30 a.m. Does that work with state?
We will make it work.
Defense, does that work with defense?
Same as the state, will make it work.
All right. At this point in time, based on the jury verdict of guilty, I'm remaining you into custody, Ms. Nix. You are to be with the sheriff pending the pre-sentence investigation report by the Florida Parole and Probation Commission. Your bond is hereby revoked. You will be held at no bond. I hereby order the Florida Parole and Probation Commission to prepare a pre-sentence investigation report upon the defendant and furnish same to the court as soon as practicable. You will appear April 3rd, 2025 in the Hardee County Courthouse at 8:30 a.m. I've set aside a full day for the sentencing. I ask the defense and the state to be prepared to present their arguments and testimony that they feel is appropriate to have this court sentence Ms. Nix in accordance with this verdict. Anything further, state?
Nothing further, Your Honor.
Anything further, defense?
No, Your Honor.
All right, all rise. I'm going to get off the bench. Come on outside.
No, he does not want to be outside. I think just.
All right, ladies and gentlemen, court is adjourned. Everybody can exit the courtroom now, please. Thank you. You can have it. You're gonna finish your problem?
Yeah.
The truth is